Financial for withdrawal, my lord, tomorrow.
Okay.
This is the Lordship. Lordship, this matter was posted on 19/7. Yeah, my Lordship has fixed this matter to be listed tomorrow, my lord, but somehow that has not been listed, my lord, tomorrow. This order is already clear, my lord. Tomorrow, Lordship has passed an order.
If there is an order, it will be listed.
This has not come, my lord. That is why I'm making a prayer, my lord.
Okay.
Deep your blessing.
Wait, please, Your Lordship.
Because tomorrow's supplementary list has not yet been released. It may come in supplementary list.
I'll submit the
Okay, you submit the paper.
Item number 39. Possibly diary is also not there. Appeal was which FSL report was called from, FSL appeal not taken. Can I pay for first week of August, any date,
Heard Mr. N.J. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, who prays for learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. When? 6th of August.
Public. Deeply.
It is your lordship. Lordship, I beg to make a mention for listing of a new matter, bail application.
When have you filed?
Yes, today morning I filed. Lordship, another connected matter is being listed tomorrow, item number 3 of the same PS. If your lordship may kindly permit.
Okay.
Deeply
Yes,
obliged.
please, Your Lordship. I'd like to mention an IA for listing, my lordship. It was filed on 16/7/2025, my lordship.
I in respect of?
In respect of modification of an order, my lordship, passed by the this honorable court, my lordship.
Okay.
Can it be fixed on Monday, my lordship?
Monday, 29. Tuesday.
Highly obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention 2 criminal petition matters.
For listing,
Yes, Your Lordship.
criminal petition you have to mention before senior court, other courts.
Please, Your Lordship. I recommend item number 58, Lordship. May I be possible for that day?
On request of learned counsel for the petitioner, this anticipatory bail application is adjourned for the day. The interim order shall continue. Case diary is there. Let it be listed again on 19th of August. The case diary be sent back to be called again on 19th of August. Or will you retain? It is long.
No, please not taking. Sorry. 19 August.
19 August. CD portion to kati dibo. Yes.
May it please your lordship, I beg to listing for a regular bail application, lordship. Petitioner happens to be a 79 years old man. He's in a very critical health condition. Lordship, his incarceration for last more than 1 year and 6 months. And this case was supposed to be listed immediately after vacation, lordship.
When?
Kindly tomorrow or day after tomorrow, lordship.
30, Wednesday. Tomorrow it will not reach otherwise on 30.
Lordship, I insist for day after tomorrow, lordship.
Why?
Even it is not reached, lordship, let it get listed. Day after tomorrow, lordship, 25th.
Okay.
I'm deeply.
I get some mention listing on regular bail.
When have you filed?
Last posting was 19/7.
What is the next date?
Next date, lordship, 8th of August, lordship.
So it will be listed on that day.
Lordship,
When there is an order, there is a judicial order, 8th of August.
Daily list motion भी है item number 1.
Yes.
Basically, lordship, for non-furnishing of ground of arrest, lordship. There is a case and the is your NDPS recovery of ganja, lordship, 43.34 kg. That is from a house of another person, lordship, where I was present there, lordship. And the FIR says that I admitted, I went there to purchase, lordship.
Case diary is there.
Charge sheet.
Charge sheeted case.
Charge sheet is there. Lordship will kindly see the page 38, Lordship. So page 38 and 39.
Since when you are behind the bars?
Lordship, from 13/9/2024, Lordship, 313 days, Lordship.
Heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the scanned copy of the trial court records as well as scanned copy of the case diary of Satyabari PS case number 124/2024. List this matter 8th of August.
Much obliged, Your Lord. Much.
Item two.
May I please your lordship, this bail application, my lord, under section 483, my lord. The accused was arrested on 21/4/2024, my lord. And for the offense committed under section 370.
Charge sheet has been filed.
My lord, charge sheet is not filed, my lord. For the last 1 year, more than 1 year, that is 12-13 month, my lord, he is in jail, my lord.
POCSO case, Lord.
Heard Miss B.R.A. Sultana, learned counsel for the petitioner. Also heard Mr. K.K. Das, call for the case diary and issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 12th of August.
My please, Lordship. For other petitioners, it is fixed on 4th of August, Lordship, for CD.
Same case.
Yes, Lordship.
Heard Mr. P.K. Savaria. Also heard Mr. K. Das, KK. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Release this matter on 4th of August.
Along with BA number 2223 of 2025.
Not along with, on that day you may pray.
Lordship.
Item four.
Also,
Also, in this case, the allegation is a suspected money laundering transaction from one account to others. So, with a group of.
What is your name?
M.U. Ahmed.
Heard Mr. M.U. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case diary. Let this case be listed on 12th of August.
Item five.
Wait, please. Here, my lord. 6 kg of cooked meat, my lord, was recovered from a hotel, my lord, where I was working, my lord. As on today, my lord, 22 days in custody, my lord. It's from Kokrajhar, my lord. May I pray for a short date, my lord?
Heard Mr. K. Borua, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case diary. List this matter on suggested date 5th of August.
Can it be, my lord, next week, my lord? Already 22 days, my lord, and it was recovered from a hotel where I was working, my lord. And suspected to be beef, my lord.
You suggested it.
Next week, my lord, any date, my lord.
5th of August. You are late.
29, 20, 30, my lord.
30.
Item six.
Obliged.
Lordship, CD may be called for and notice may be issued to the respondent number 2.
Heard Mr. A.T. Sarkar, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on 13th of August.
Okay, some little bit earlier, Lordship. I'm praying for on 11th, Lordship. 11th
No,
March.
13th. Date cannot be as per your choice.
Item seven.
Please, Lordship. Also pending investigation. Is that under POCSO Act, Lordship?
Heard Mr. D. Medhi, learned counsel for the petitioner. Same order, earlier order.
Lordship, it is 70 days and on 11th of August, it will be 90 days, Lordship.
11th of August.
Item A,
Lordship, notice may be issued, Lordship.
Yes, same order.
This bail application is filed in connection with GB
It is
crime
pending investigation or charge sheet has
Yes.
been,
pending investigation.
will call for the case diary.
Lordship, and we heard on the point of this
Furnishing of.
non-communication of the ground of arrest.
There may be some document in the case diary.
Document is there, 47 notice is there. That notice is not a ground of arrest. I would like to submit. And so far as communication is concerned, I'd like to submit, Lordship. The accused doesn't know other than Koki language. The documentary evidence is there. The statement of the special judge is there. So in the statement was recorded by interpretation by help of interpreter. So the notice under section 4 LS notice, which is not a ground of arrest, I would like to submit. LS notice was in English, and learned special judge had recorded that the accused doesn't know other than Koki language. So I'd like to submit on this two legal points.
No, let the case diary be produced.
It is apparent on the face of the record.
There may be some other document apart from 47 also, because in NDPS Act, 52 also mandate.
Yes.
Section 52 also mandate. So it is not only 47 document notice. There may be some other document in the case diary which may show that grounds of arrest were.
But the Lordship, the prosecution has submitted the grounds of arrest as the notice under section 47. And the learned special judge has recorded his statement stating that the accused cannot speak any other language except Koki, and therefore Mrs. So-and-so, bench of the civil judge, junior division, Silchar is appointed as interpreter. And the statement was recorded. And the notice under section 47 LS notice is recorded in English. It is given in English. And that notice is also, Lordship, it is just stated that you are hereby informed that you are arrested in connection with so-and-so for violation of NDPS Act in connection with seizure of so-and-so metamorphin tablet. The case is non-bailable. That is not a ground of arrest, Lordship. Lot of materials were available before them. The seizure memo and this forwarding report, all these things. Many things were written by them. But this is not a ground of arrest, Lordship, as interpreted by Honorable Supreme Court in the Bihan Kumar as well as Procedural, Lordship. And so far as the communication is concerned.
Yes, Miss Deccan.
In the meantime, we are filing our written objection also.
Lordship, we may be given interim relief, Lordship, because Honorable Supreme Court says that if it is the arrest is illegal.
No, Mr. Ullah, your submissions needs consideration, but for that, this court intends to peruse the case diary also, and let us also give chance to the prosecution to file. Because 9.8 kgs of methamphetamine tablets were recovered from your possession. Heard Mr. Learned Counsel for the petitioner. Also heard Miss N. Kakoti, Learned Counsel appearing for NCB. Learned Counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on the ground that the grounds of arrest were not furnished to the petitioner in the language understood by him. He submits that petitioner understands only Koki language, and the notice under section 47 of BNSS was in English language. He also submits that the said notice also does not contain any grounds of arrest as mandated by the apex court in various of its judgment. To appreciate the submissions of Learned Counsel for the petitioner, this court intends to peruse the case diary. Hence, Call for the case diary. Learned counsel for the NCB has submitted that the NCB intends to file a written objection against the prayer of the petitioner, hence seeks some time for doing so. The prayer is allowed. Let this case be listed again on 6th of August.
Item 9.
Wait, please, Your Worship. Worship, this is a regular bail application in connection with Vishaka PS case number 91 of 2025.
What is your name?
Muhammad A. Rahmani.
Heard Mr. A. Rahman, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Let this case be
13.
13-8.
Highly obliged.
Item 10.
Wait, please, Your Lordship. It's a charge sheeted case, the LCR will be required, man.
Heard Mr. N.J. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the
Page 1, man.
scanned copy of the trial court records along with the scanned copy of the connected case diary. The registry to take steps for requisitioning the same. List this matter on 19th of August.
Item 11.
The POCSO matter, notice to go
Heard
to.
Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Charge sheeted case.
Yes, ma'am.
Charge sheeted.
It's about my pending call. Scan copy.
What is the status of the trial?
So far, my instruction, no witness examined till date.
No witness examined. Call for a status report of the pending trial from the trial court as well as scanned copy of the case diary. Stop. Registry to take steps for requisitioning the same. List this matter on 19th of August.
Too long. Can it be, other two queries has been released, my lord. I have been falsely.
Shorter.
13.
13th of August.
Item 12.
Sorry, 13. Can it be 12?
Okay, 12th of August.
Regular bail application also. PS case number. So may I pay this is worship may call for the CD.
Heard Mr.
H.
A. Chetri, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. List this matter on
No problem.
30,
30.
37.
Problem.
Item 13.
CD is available. Yes, what is your case?
No, not along with the another. 61.
We'll take it up along with 61.
Problem.
Item 13.
Yes.
The petition was registered on, my lord, 3/6/2025.
Hmm.
Today, about 51 days.
What is the offense?
Option, my page 12 is the FIR, my lord. Cattle Preservation Act. Section 13 is there. Only, my lord, my concern land of detention. Page 12.
How many days? Where is the rejection order?
Yes, my lord. Page 17, my lord. And forwarding report is my page 13.
Case diary would be required.
My lord.
Case diary.
Page 13 is the forwarding report, my lord. And
Yes, Mr. Das.
3/6.
On.
How many days you are behind the bar?
51. Okay. And 13 foreign report, my lord.
First of August.
Let the also kindly say. 13 is a foreign report. So I arrested on 3/6/2021. I was ordered to the jail custody, my lord.
No, I have seen the rejection order. When will you be completing 60 days?
9 days left, my lord.
1st of August. Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case diary. Let this case be listed on 1/8/2025.
It will be 30 of this month, my lord.
37. 37.
Item 14.
Make regulation. A regular bail application, my lord. Petitioner behind the bar since 35 days today, my lord. When it appear, when it test, but
Heard Mr. H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Let this matter be listed on 6th of
similar case out of the same affair, my lord, has fixed on 25, my lord.
25.
Lordship.
Okay, 25th.
Item 61 from supplementary list.
Along with the 61, my lord, 65, 65 also may be taken. And as per my information, CD is probably here, my lord.
Case diary is there. Yes.
My lord may be taken up, take up the matter, my lord, 2293, my lord, 363.
Item number 2343.
2293, man. Where case there been called for, man. My lord, primarily, my lord, the lordship will. Page 15 is the FIR, my lord. Page 15, ma'am.
Yes.
Reference to the subject cited, I have to honor to report that on 15/7/25.
Oh, you are lady.
My lord. Station received the information.
You put flowers.
Yes, I'm basically, my lord, I'm engaged for the looking after the hygiene, flower, and the other management, my lord. Basically, that's part, man. I'm no way connected the day-to-day official activities of that particular section. Looking or the other activities, my lord, administrative side of that particular neighborhood. I'm neither a owner of that particular one. Owner is somebody else. Lordship can to see the owner, my lord. Lordship can to see the document. Page 33.
Yes.
That's the ownership agreement, my lord. LLP agreement, my lord, between Pavan Kumar Sharma, Rupa Sharma. They are the owner of that particular resort, my lord, where alleged gambling took place now. They are not before your lordship, my lord.
What is the accusation against you?
My lord, basically acquisition against me, my lord. Lordship kindly see the notices. Page 24 now.
What is the date of your arrest?
Date of my arrest, 15. Produced on 16.
15/7.
Yes. 8 days in custody, my lord. So basically, my lord, Lordship kindly see the page 24, or Lordship can take up the forwarding it. Also page 19. Same, my lord.
Yes.
Has Lordship got it, my lord. Page
Yes, yes,
24, my lord.
yes.
During the investigation, various incriminating articles, the materials such as 210 casino poker chips, various color anti-chips, covers, cards, deck, poker dealers, button, lottery bingo machine, tombola, housing board, casino calculators, HDFC, Viper soundbox, cigarettes, lighter, alcoholic beverages, mobile phone, wallet containing case and other related items were recovered and duly seized from the possession of you and your accomplished person using illegal gambling. We search the place of occurrence, the room number 238 of the Club Nirvana. So basically, these materials were seized from the room number 138 of Club Nirvana. That indicates a very sensitive, important nature, having the ramifications where the interest of the gamblers, human traffickers are involved. It is found that during the investigation that you are professional illegal gamblers involved in the running, supplying, logistics, gambling tools, provided funds, engaging a huge number of youth and new generation towards the game showing social activity and the humanist illegal gambling. Now, 4, that the accused person, namely 1, 2, 3, and 4, my lord, 3, were found have been sheltered and facilitating you and your accomplished person in the resort premises by the accused POCSO. This is important. So they have been booked in particular rooms by the POCSO manager of the resort and the resort owner, respectively, Jyoti Sharma. Well, this is absolutely, my lord, not a correct information, my lord. She is not the owner, my lord. Subsequently, they have changed that statement also, my lord. I'll come to that. Sri Abhishek Sharma, for their wrongful illegal gain and connection with the instance. During the investigation, it has been revealed that the accused person, Sri Deepak Saikia, manager of the Club Nirvana, has been involved in human trafficking activities in and around the resort premises as well as the Guwahati in collaboration with the associate in connivance with the owner of the resort. I'm not the owner of the resort, madam. It has come to the light during the investigation, both the resort owner, Jyoti Sharma, and Sri Abhishek Sharma were aware of trafficking and supply of the girls to the resort and nearby lodges. Such activities such as harmful immoral message to the society in which you are involved, and there are sufficient evidence regarding the same. During the course of investigation of the case, you are found actively involved in the organizing, participating in the illegal games and betting within the premises of the Club Nirvana Resort. Various gambling materials, including the casino poker chips, card decks, dealer buttons, so and so machines were recovered from the possession of you and your accomplished person. That during the investigation, you have found the habitual offender involved in well-organized criminal syndicate, network games, betting, and human trafficking across the multiple states and northeast. 4 accused persons from the Mizoram were being facilitated, sheltered by the owner and the staff of the Club Nirvana to carry out the illegal activities such as game and betting and human trafficking. That role and involvement are amount to the criminal conspiracy aimed at the promoting illegal organs to possible trafficking, thereby endangering public order, morality, and security. So this is the possible trafficking. Now, here
The police not registered the case, madam, under the Immoral Traffic Act. They have only registered the case under section, madam, 143 and 317(4). That is theft, madam. Theft, there is no allegation, madam. So
Stolen property.
that is receiving of stolen property, madam. And the 143, basically. And the Special Act, madam, Games and Betting Act, 1415, madam. Now.
What is 143?
143, madam, that's the very important aspect, madam, of this case, the human trafficking, madam. So can you take up the 143? The requirement of the 143 is very specific. Mary, madam.
Yes.
Whoever, for the purpose of exploitation, first of all, recruit, transports, harbors, transfers, or receive a person or persons by using threats, using force, or any form of coercion, by abduction, or by practicing fraud or deception, or by abuse of power, or by inducing, including the giving or receiving the payment or benefits, in order to achieve the consent of the person having control over, now this is very important, having control over the person recruited, transported, harbored, transferred, and received. So my lord, first requirement is my lord recruitment. I have to recruit somebody.
So you say that these ingredients are not there in this case.
Against me now. There will definitely reveal my lord. I'm not an owner, my lord, very specific.
Okay.
And my husband is not also anyway connected.
Who is your husband?
The next petitioner, my lord, in item 61, my lord. The next page, Abhishek, my lord. He just went to pick me up, my lord, the wife, because her physical condition, my lord. And he was also picked up, my lord. They are not the owners, my lord. He is absolutely no way connected, but she is an employee of that particular resort. Now, in this case, to register a case, my lord, under 143 initially, my lord, the requirement of that I must recruit somebody, my lord. Or that's because said, my lord, that for the purpose of exploitation, and I must for the recruitment, then I must use threat or force or abducting or by practicing fraud, deception, abuse of power, or by inducement, including giving the receiving payments of or benefits in order to achieve the consent of any person having control over the person recruited. So that whoever I have recruited, I must have this control over that person, first of all. Basically, this section was initially incorporated in IPC during the long back, because at that time it is a case of the slavery, but the slavery concept was not subsequently in India, but that remains. So the slavery, there is no definition. But the concept came up from the slavery, Person has to be recruited for these purposes, with the coercion, faith. These are the requirements of it. My humble case is that I'm not a recruiting officer of that particular premises. Neither have coerced anybody, paid anybody, because the recruitment of the first ingredient is the recruitment, or harboring. There is no harboring at all.
Okay, okay.
And receive also. So recruitment must be, I must involve. Not only recruitment, then the subsequently on my lord, exploitation. Two ingredients. Then, my lord, these persons, my lord, page 28, my lord, what you can see. Who has booked the resort? They have, my lord, page 26, my lord, what you can see. Only one person, he has booked the resort for all the person, my lord, who is arrested, my lord. He has booked the resort from 9/7 to 14/7. And accordingly, he made the payment also.
And Lordship kindly see the terms and condition of stay also incorporated in page 26 itself. Terms and condition. First condition was the premises are to be used strictly for the residential purpose only. Use of the property for any unlawful, unethical, immoral activities is strictly prohibited. So he has booked it. Then Lordship, he made the payment, page 28 to the HDFC Bank. Date, my lord, 2/7/25 itself. 3 lakhs he has paid for those 4 days, my lord.
Okay, what is your submission?
Then, my lord, this is the guest list we have provided beforehand to the police on page 31 itself, my lord. During that period. It's not hidden. The guest list was already uploaded in the website of the police as required under the law, including name of the apprehended person.
Now, what is your submission?
My humble submission is that I'm no way connected, madam, regarding the human trafficking or the gambling.
Okay,
My only is to look after the hygiene of that particular places.
okay, where is the case diary?
Then, and apart from if that lady, as Lordship already seen, there is a medical report was also called for. I don't know whether it is available. Is already, my lord, there's a miscarriage
Whether medical report has arrived? Okay. I'll come.
and she had a miscarriage and right now she has a kidney stone also. Now, Lordship can take up the yesterday, my lord, each person, my lord, I was initially, my lord, on the first day itself, the lady was forwarded to the judicial custody, my lord. Rest all the mail was forwarded to the police custody for 5 days remand.
Okay.
So the lady was sent to JC, my lord. Now, on 21/7/25, my lord, they were produced, the other accused person, my lord. On that day, my lord, Lordship can see the point 12. There are 5 persons, my lord, right now. 6 out of them, 4 were shot. In total, my lord, 5 persons was produced, 6 persons was produced yesterday, my lord. Including the petitioner, my lord, in the other case, my lord, my husband, Abhishek Sharma, will come before you. And Deepak Saikya and the 4 major people, my lord. Out of them, my lord, now point number 12, my lord. IO has paid for another 5 days of the police remand of the accused Tailo, Dalte, Lalingetha, and Joseph Lal Parmoya in the case to interrogate about the documentary and the digital evidence, including the transaction records, mobile phone, bank details, and the other devices used for the commission of the offense. So police custody was again sought for by the IO against those 4 persons only who were guests and from whose room all the articles been recovered. In the seizure list, that is very clear, my lord. In the next petition, I'll come to the seizure list, my lord. Next, Lordship can come to the page, point number 21. Of the order, my lord. The IO has stated that after 5 days of interrogation and investigation, it has been found that 4 accused persons whose further remand has been sought for are involved in high-stake gambling, where huge amount of money is involved, and there is indication that the owners and the management of the club Nirvana may also be involved in such activities Therefore, further interrogation remains to be done, and also the 4 accused persons have not cooperated. So, yesterday, they sought for the further interrogation, my lord, and the 5 days police custody, and where it is very specific that they are not sure, even after 5 days, whether we are involved. This Club Nirvana were involved in such activities, my lord. This may be involved, my lord. So, my remand or my custody was not sought for, my lord. Neither me, neither my husband. Their custody was not sought for.
Okay. Yeah,
Now,
yeah.
Lordship, can you see the other petition also, the 2343, item 61, my lord, page 29. Page 29, my lord. This is the seizure list. The undersigned do hereby search premises the Club Nirvana Medic, which is room number 1, 3, and room number 8 of the old building first floor. During the search below, deceptive articles has been recovered and seized from the joint possession of the 1. Number 2, 1 is my lord Lanchen Hima Silo. Number 2 is the Ralte. Number 3 is Raling Geta. And the number 4 is the POCSO, manager of the resort in his presence, my lord. From the room number 1, 3, and 8, my very specific. From their possession, all the articles have been.
Who is Abhishek?
Abhishek?
Is your husband?
Yes, ma'am. He is
No, who?
He is my husband.
Is he an employee of?
No.
How?
No way connected.
How he's linked?
I don't know. Absolutely, I have no idea.
When he was
On that
arrested?
day, itself, because he went to pick up his wife, my lord, which is a regular feature, my lord. Because of
Okay.
then he was also picked up from the resort. He is absolutely no way connected, my lord.
Okay. Yes, Mr. Sharma.
And the other also, my lord,
You have
page, my lord, 42. In the first remand order, what happened, my lord?
of Abhishek.
All, my lord.
Okay.
All 7 acres, the first remand order. What they found, my lord, basically, at the instant case, IO has seized certain items prima facie received reveals they might be used for gambling activities, and most importantly, the IO has produced certain pictures of a woman which are retrieved from the phone of the accused Deepaksha, who is an employee of the Club Nirvana. As per the IO, based on these materials, further interrogation is necessary. So basically, they have retrieved some pictures from the manager mobile phone number, and from they have concluded that there may be an angle of the human trafficking. So before that, my contention is that when they have arrested, when they have registered the case, there is no material as such to register the case under 143 manner. When the FIR was registered. So where from the FIR, where from that material initially, because initially from the FIR is very apparent, they went to only on the basis of information, secret information regarding that the illegal activities of the gambling. So accordingly, they have registered the case on the first day. It was under the gambling activities. They have seized the items.
Okay, that you have already submitted.
So my contention was that why they have added 143 on the first day itself.
Your submission is that there is no basis for adding.
No basis, they have only, because otherwise if they can immoral activities there, then the requirement of the 35 note is important, madam.
because the punishment in the Immoral Activities Act is 7 years. Betting Act also punishment is only 3 years, madam. And the notice under section 35 is necessary to bypass that. Without any material, they have added the section of the receiving stolen property. There is no mention of receiving stolen property anywhere. In spite of that, they have registered because it's also may amount to 10 years punishment. No notice is required. Then also Immoral Trafficking Act, no notice is required. So in spite of that, why they have not registered the case under the Immoral Trafficking Act? It says that, and they are saying that there are some immoral activities are going on in the craft premises. In spite of that, till yesterday, they have not a single prayer for registering it under the Immoral Trafficking Act. Simply, it's a human trafficking. For human trafficking, these are the ingredients. However, the recruitment is very much necessary, madam. And I must have the control over that recruited person to do the immoral act, madam.
No.
So, let him submit, madam, then I will reply, madam. There is anything remains.
Yes, Mr. Chair. Yes, Mr. What is your submission? Come this side. From your possession, gambling articles were received, recovered.
That is incorrect, actually, my lord. My lord, I had come down to Guwahati, my lord, to source, my lord, materials for my shop. I was asked by another accused, Mr. Silo, that he has a room there in the hotel, so I can stay in that particular hotel. That is why I had gone there. Now, if my lord comes to the FIR and the Caesar list, if my lord comes to the FIR at page, my lord, starts at page 18, which my learned senior has already read, my lord. If my lord comes to page 18, the last paragraph.
Yes.
The search was started at 10:30 a.m. under the leadership of Officer in Charge Sonapur PS, Sonapur, in the presence of above witnesses. During search of room numbers 1, 3, and 8 on the first floor of the old building of Club Nirvana, the following individuals were found. I am at number 2, Lal Fakama Rante, aged 28 years. And certain materials were seized. But and all items were recovered in the presence of witnesses. The accused persons were brought to Sonapur, so and so. Later on, the owners and managers, they were
Now, what
brought.
is your submission? I know now. By now, I know about the facts.
Fine. My lord, the seizure is not from me particularly.
From the room where you were found.
But my lord, 3 rooms. But from which room? If there are 3 separate rooms.
Okay,
one,
it has
3,
not been
8,
specified. That is yours.
been specified from which particular room, from which person. There are 4 persons, my lord.
Okay.
Insofar as I am concerned, these were not seized from my possession. From my possession, what was seized, my lord, was only a phone and 22,000 in cash. And my lord will see another aspect, my lord. What is the cash amount recovered? At page 20, 22,000 from my wallet, not from the table or not from anywhere else. If a game of gambling is going on, my lord, the money will be on the table or on some designated place. Page 20, serial number 21, one iPhone 15 Pro, sorry, my lord, page serial number 20, one iPhone 13 Pro mobile along with black color wallet having cash amount of 22,000 from the possession of Rante, that's the petitioner. Serial number 21, iPhone 15 Pro Plus, OnePlus Nord mobile along with earpods, one wallet having cash of 1,750 seized from possession of Lalring Heta. 22, iPhone 16 Pro Max along with wallet having cash amount of 680 rupees. So this is the total amount of money, my lord. This will be about 24,000. From wallets. If a game of betting or gambling is on, my lord, the money will not be inside the wallet. Now, before that, my lord, the search and seizure, there was no warrant produced. The Game and Betting Act, my lord, requires the search and seizure to be under a warrant or under a direction if my lord takes up the Game and Betting Act.
Games and
Now that I have a copy.
Yes. Which provision?
My lord, section 7. If a district magistrate or a district superintendent of police has reason to believe that any house, room, office, enclosure, space, vehicle, vessel, tent, or place is used as a betting house, he may either himself enter or by his warrant authorize an officer of the police not below the rank of a sub-inspector to enter with such assistance as may be found necessary by night or by day, and by force if necessary, any such house, room, office, enclosure, space, vehicle, tent, and may either himself or by the police officer authorized as above take into custody all the persons whom he has so and so, my lord. My lord has read the FIR, my lord. My lord has read the forwarding report as well. There is no mention of any warrant. In fact, there was no warrant. This person, the police officer who is the informant, he himself went, and he is not authorized to conduct a search or seizure without any warrant. He is a SI probationer. If my lord comes to page 22, the name of the informant, he is a SI probationer. He is not authorized, my lord, to enter into any such place on the, my lord, even if he has any information that there is any game of betting or gambling going on, he has to first take a warrant. This entire seizure, my lord, is without authority of law. And further, my lord, what has been seized? The seized materials, my lord has already seen the list. These are playing cards, some poker chips. These are not banned items, my lord. Some alcohol bottles. To my knowledge, my lord, Assam is not a dry state. There are some cigarette packets. None of these are banned materials. So why have they seized them, my lord? And the FIR also does not say that any game of gambling was going on. If there was no game, on what basis, my lord, have they arrested these persons? This entire arrest, my lord, firstly, the search is illegal. Secondly, my lord, the seizure is illegal. My lord, thirdly, the seizure is not specific as to from where they have seized it, from whom they have seized it. They say room number 1, 2, and 3. All the materials, my lord, will not be in 1, 2, and 3 combined. In room number 1, there may be something. Room number 2, there may be something. Room number 3, there may be something else. From which room? My lord, there is no gambling that was going on. Seized materials are not banned.
What is the penal provision in Assam Games and Betting Act 14?
My lord, 3 years. 3 years.
No, which one is the penal provision? 14.
14. 14 to 17. We have been added under 14 to 17. My lord, if my lord comes to 14, my lord, not exceeding 3 years, not less than 6 months, but not exceeding 3 years, and a fine of rupees 1,000, not exceeding 2,000. 17, my lord, not less than 6 months, not exceeding 3 years, fine of 1,000, but not exceeding 2,000. Then 16, my lord, fine of 1,000, not exceeding 2,000. My lord, same 6 months, not exceeding 3 years. The maximum is 3 years.
Okay. Yes, Mr. Sharma. Why this lady has been arrested? In item number
65.
65.
With reference to section 143, trafficking of persons. Lordship has already gone through the provision. Here, Lordship will find purpose of extradition recruits. That is relevant, and all these A to F grounds are there also: using threat, force, abduction, practicing fraud, abuse of power, inducement, including the giving or receiving of payments or benefits. So that is the criteria, and also Lordship, the 2 and 3, it may extend to life if victim trafficking is involved of more than one person also. Here, Lordship, what has happened in the resort, Lordship, one of such victim girl has been recovered. Our 180 statement has also been recorded. In her 180 statement, she has revealed, Lordship, how she was exploited and forced into prostitution. He happens to be a dancer. In events, she used to dance, Lordship. In one such event, she danced.
Whom she has implicated.
Yes. Thereafter, Lordship, the original owner, main owner, Lordship, who is absconding, is not before a Lordship. He recruited her using threat and giving her money, Lordship. In lieu of money, she was recruited, and thereafter, Lordship, from her statement, other names of 5 girls have come up, Lordship, who are yet to be examined. And in her statement, Lordship, will have flag mark, Lordship, will kindly go through it. There, Lordship, she has also implicated the present two petitioners, Lordship, including the lady and her husband. As been, they are looking after the affairs of the resort, and they are aware of what is happening regarding the prostitution. Everything has been recorded in a wonderful statement. I have flagged my Lordship. Thereafter, Lordship, all the employees of the resorts have been examined. Their statement, Lordship, will see what in a nutshell, Lordship.
No, I will go through the case diary.
Yes, yes.
But how this petitioner is involved and her husband is involved?
Yes.
How? You need not to read out, I will go through. But how she has implicated, in what manner, what is their role?
He is the one who is looking after the resort, Lordship. She is managing the day-to-day affairs, Lordship. The booking which was done, Lordship, it was done on her behalf. She has
Booking of
all the guests, Lordship. In that resort, Lordship, there are 32 rooms. In a bulk, all the 32 rooms were booked by one of the arrested accused person. And the manager was informed by the present petitioner, Lady Lordship, to give them VIP treatment. That is here in the statement of the arrested manager, Lordship.
No, but how she is involved in human trafficking under
Yes.
143?
Yes, I'm coming to that, Lordship. So, Lordship, regarding booking part, she was the one who telephoned the manager to look after them and give them VIP treatment. Thereafter, Lordship, the gambling was held in the banquet hall of the resort, Lordship. And Lordship, all the statements of the employee, Lordship, will see it was done and the banquet hall was covered with a black cloth so as that nobody can see what is going on inside. That is the specific statement of all the employees. Poker table was laid, Lordship, and this is a sophisticated gambling, Lordship. This is not some, Lordship, going by the cash money. It is done online. All the WhatsApp chat, including the photographs of the gambling table, Lordship, it is
No, regarding allegation of gambling,
yes,
even if it is
yes,
believed, it entails a punishment which
yes,
requires a notice under 35(3) to be given. If my query is how the petitioners are involved in human trafficking.
yes, Lordship. Regarding human trafficking, also I have already stated.
Suppose one girl was found who was exploited,
Yes.
whether she has named any of the petitioner
Yes.
as being involved in human trafficking.
Yes, that's what I'm saying.
She has named.
She has named.
Okay.
That she was used along with 4 or 5 other girls.
By these petitioners.
Yes, they were used as to facilitate some guest, Lordship. On special request, they were asked to come to the resort, and thereafter they paid. There is, Lordship, WhatsApp chat of the victim girl whereby the rates are given for one night, including other girls. Lordship can kindly go to the.
Okay.
That is there, Lordship. There is no doubt about it. Lordship will kindly go to the WhatsApp chat. She has named 5 other girls, Lordship, who are yet to be examined. And one more important thing, Lordship. When the raid was conducted, Lordship, she in her 183 statement stated that she was telephoned by the present petitioner and also the absconding accused to flee from Guwahati, to run away from Guwahati. Because police are raiding, you will be caught.
Who? Present petitioner means?
The lady, Lordship.
Okay.
So that is in the 183 statement, it will clear up everything, Lordship.
Okay, give me the case study.
Yes. Lordship, regarding one more thing, Lordship, this gambling part, Lordship. This is a sophisticated gambling, Lordship. Here, cash money is not used. Here, Lordship, online transaction is being done. And if Lordship kindly goes to the, I flag marked everything, Lordship. The petitioner, before your Lordship, regarding the gambling part, Lordship, he uses 2 account number, Lordship. And Lordship will kindly see the screenshot of those gambling part, Lordship. Just to clarify, so I'm just pointing it out. This gambling, Lordship, is done. It was organized quite a few times, Lordship, and people from all over India are invited here, Lordship. Lordship will see all the 32 rooms were booked. Around 60 people were there to participate in this gambling event. This is not some cards game, Lordship. This is a poker game, Lordship, very sophisticated gambling. And here, Lordship will see the WhatsApp chat. Kolkata guys confirmed, Bangalore guys confirmed, Delhi guys, Northeast guys, and from other cities as well. The money that is being transacted, it runs in crores, Lordship. All these are WhatsApp chats, Lordship. I have flag mark.
Okay, heard Mr. A. Mbora. Yes.
Probably my case is, my lord, yesterday they also filed one objection, my lord. And Lordship kindly go through one judgment. Well, gambling is a gambling, maybe high profile or low profile, that's a different issue. But the act concern is the 3 years punishment, not more than that. There's no separate act for the high profile such gambling. I have filed to understand, madam. what is
Okay,
high
no,
profile.
I'll go through the case diary, whether there are ingredient of 143.
Yes, madam. Regarding the 143, the learned public prosecutor himself has submitted, they were recruited by the owner. I have not tested.
Oh, okay, let me go through the case
Yes.
diary.
And that he also said, my lord, they were asked to come to the resort. They were asked to come. That means what? It's a voluntary one. They were asked to come. They have voluntarily come. It's not the case, my lord, they have been recruited. If it's a voluntary, my lord, then the immoral traffic act comes, my lord. The 143, what are the requirement, my lord? First requirement is the threat.
Okay,
First-
let me go through the case
Yes, my
diary.
lord.
I have
What
understood.
he submitted, I'm just because I don't have the access of the 164 statement of the victim. That is what alleged victim has stated, my lord.
Your
So what-
submission is unless the ingredients
Yes,
mentioned
ma'am.
in the 143 are there.
Yes. The 143, he himself said they were called for, my lord, over telephone. What is the requirement of the 143, my lord? It has to be using force, using threat or abducting, then practicing fraud or abuse of power. Now, the second part is whether there is any sexual exploitation, my lord. What kind of exploitation in the statement, my lord? And who did it and whose instruction? And the Lordship kindly see that yesterday, my lord, they filed a bail objection. They are very specific, my lord, that they were recruited, their own statement, by the owner of the Club Nirvana, my lord. Page 3 of the yesterday, my lord, Lordship kindly see. The certified copy, my lord. Their case is that they were recruited by the absconding accused Pawan Sharma, owner of the Nirvana. Now owner is somebody else, their manager is somebody else. Now they are saying that I am looking after. If there is a owner is somebody else, the manager is somebody else, how I am involved, my lord. And their next is regarding the other petitioner, there is nothing. The Lordship can list in that.
Okay, you need not to repeat. I'll go
The
through.
accused person, my lord, require the police custody, my lord. Only the POCSO and the.
This you have already submitted.
No, my lord, Lordship kindly see their old petition, my lord. Their own yesterday's petition, my lord, before the trial.
Yes.
The name and address of the accused person not required in police remand.
Yes, only.
Deepak Saikia, he is not before your lordship, and Abhishek Sharma. Abhishek Sharma is before your lordship. His remand was not sought for, my lord, yesterday. Then in their bail objection, the ground is that it was the owner has recruited this lady. There is no whisper about the Abhishek in the nowhere, my lord. He said he is also actively involved. The yesterday's application, my lord. There is no whisper about Abhishek, my lord.
Okay.
And how she has recruited. My lord, there has to be some recruitment, my lord. First of all, they said that she was recruited by the owner.
if this was requited by the owner, how I am involved, my lord. But the requirement and see, they said they were asked for over telephone. Then is there a coercion, my lord, threat, my lord? They voluntarily they have come, my lord, that means if they have come at all.
Okay, that I will see and that I will verify.
Well, he has he stated, but that's what I'm saying.
Okay.
Because I have
What
no
is this judgment?
And what is my state, my lord? I have given it a VIP treatment. Is it an offense, my lord? Giving the VIP treatment to the borders, my lord.
So your submission is you are no way connected in the offense under section 143
Yes,
of.
ma'am. Their own statement says, my lord, it was the recruitment, if there is an at all recruitment by the owner, their own petition, my lord. It's not by me. The recruitment is the first ingredient, my lord. Then there is force, coercion, these are the requirements.
What is this judgment?
This is regarding, my lord, games and betting, my lord. If para 7 and 8, the transaction, when there's a transaction going on, then they have to apprehend. Simply apprehending something, poker chips or anything related to the gambling, it does not fall within the Gambling Act. Court cannot presume, that's the court, the judgment said, that it is for the purpose of some illegal activities, only on the possession. What they said, my lord, because everything was recovered from 3 particular rooms. And they said that there is a statement that this gambling was going on, my lord. So my only contention is my husband is absolutely no way connected. Yes, I am an employee of that particular resort and my role is very limited, my lord. Role is very limited, my lord. And apart from there is a medical emergency in my case.
I heard Mr. A.M. Bora, learned counsel for the petitioner, assisted by learned senior counsel for the petitioner, assisted by Mr. D.K. Baddev. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Ms. Jyoti Sharma, who has been detained behind the bars since 15/7/2025 within bracket for last 8 days in connection with Sonapur PS case number 113/2025 under section 143/317 within bracket 4/49/3 within bracket 5 of BNS, read with section 14/15/16/17 of Assam Games and Betting Act. Games and Betting Act 1970. The gist of accusation in this case is that on 16/7/2025, no, on 15/7/2025, one Abdul Qadir Sheikh had lodged an FIR before the officer in charge of Sonapur police station, inter alia, alleging that a secret information was received through reliable sources regarding illegal gambling activities being carried on at Club Nirvana, Medikusi, Sonapur, and accordingly, a team of police officials was constituted and it conducted search operation in the. Mr. Sharma, what is your submission regarding requirement of warrant under section 7 of the games, whether the search was authorized. You go through the case diary. Is any authorization is there? And if you have any other submission there, because authorization is required, appears that it is required. Whether there can be search without authorization, under what circumstances?
Good.
কি লিখলে? Such operation in the said resort, aforesaid resort. Stop. During such operation in room number 1, room number 3, and room number 8 on the first floor of the old building of Club Nirvana, certain objectionable materials which can be used for the purpose of gambling were recovered therefrom. Now, it is also alleged in the affair that the aforesaid rooms আগৰ লাইনটোত লিখক therefrom like casino poker chips card decks poker dealer button and one lottery bingo machine which may be used in gambling / casino. Stop. It is also stated in the FIR that the owner / authorities of the Club Nirvana resorts were suspected to have connived with the accused persons who booked these aforesaid rooms, namely Lalchan Hima Silo, Lal Pakwama Ralte, Lal Ringheta, and Joseph Lal Parmavia. Stop. It is also alleged in the affair that the aforesaid accused persons were provided with necessary facilities by the club authorities to do unlawful activities like gambling and other criminal acts like human trafficking. Stop. It is further alleged in the affair that the owner and the manager of the Club Nirvana resort were involved in illegal business of human trafficking, and they used to illegally procure girls and supply them to the customers in the resort premises. Stop. The present petitioner, namely Jyoti Sharma, has been named as one of the accused in the FIR. Stop. Learned counsel for the learned senior counsel for the petitioner has submitted that the present petitioner is in no way connected with the offense alleged in the FIR. It is submitted by learned counsel, senior counsel that she is only one of the employee of the aforesaid resort and was involved in. What was your main role?
Basically, the beautification and the looking after the guests, my lord.
Involved in.
Cleanliness. I'm not the owner, that is admitted fact.
Involved in looking after the resort and to attend to the guest. He further submits that the present petitioner
I'm not the
is not the owner of the resort, as has been alleged in the FIR.
Subsequently, my lord, it has been changed, my lord. Owner. Their own case, my lord. Initially, they said that I am the owner. and
He
my-
further submits that the owner of the aforesaid resort
They said that he is
are
absconding.
one Pawan Kumar Sharma and Rupa Sharma,
They are, yes,
according to you.
as per the document. And they have said that the owner is absconding now.
Stop. Learned counsel for the petitioner, senior counsel for the petitioner further submits that the the accusation regarding human trafficking made in the FIR is only on the basis of suspicion and nothing was found at the time of lodging of the FIR which justifies inclusion of the provision under section 143 of the BNS in this case. He submits that none of the ingredients as mentioned in section 143 within bracket 1 within bracket small a to small f of the small f are present in this case, as the petitioner has not recruited any person for the purpose of exploitation within the meaning of the section 143 of BNS. He submits that the other penal provisions involved in this offense entails lesser punishment for which notice under section 35(3) of BNSS would be mandatory. However, only to avoid issuance of such notice, the police has inserted provision under section 143 BNS in this case.
And 317. Receiving stolen property.
Stop. Similarly, he also submits that there is no allegation of receiving any stolen property is there in the FIR. However, the said provision has also been inserted only because of the fact of the higher punishment provided for the offense so as to avoid issuance of notice under section 35 within bracket 3 of BNSS. Learned counsel for the petitioner has, learned senior counsel for the petitioner has also submitted that the investigating officer, while producing the petitioner along with other arrested co-accused persons before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, had not prayed for any. You were in police remand for how many days?
I was not.
Had
He
not,
was not.
had not prayed for police remand of the above named petitioner.
My husband was 5 days.
Stop. He further submits that the petitioner is suffering from, petitioner is medically not fit as she had suffered from an miscarriage a few days back and presently suffering from pain due to kidney stone. He submits that in this case there are no materials to implicate the petitioner under the offenses alleged in the FIR. Hence, he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Sonapur PS case number 113/2025 and has submitted that the accused number 1 named in the FIR, that is Lalchan Hima Silo, had booked the entire all the 32 rooms of the resort, and they have all the guests have indulged in the game of betting, within bracket online betting, in the conference hall, where in the banquet hall of the resort. He further submits that during investigation, police also recovered materials indicating that the accused persons have indulged in human trafficking, and one of the victim girl who was employed in the resort was recovered therefrom. In her statement, he further submits that in her statement recorded under section 183 of BNSS, the victim girl has implicated the petitioner and other accused persons of having forced her to sexual exploitation to cater to the customers who have booked the rooms in the said hotel. He further submits that there are 5 more victim girls whose statements are not yet recorded, and therefore he vehemently opposed the grant of bail to the present petitioner.
This authorization letter is here also, under section 7 of the games and betting.
Okay. You flag it.
Yes, I flagged it.
Stop. In Ituraki, next item. Item number 61. In addition to what prosecution has stated, you have to add. Learned Senior Counsel for the petitioner has submitted that the present petitioner is the husband of co-accused Jyoti Sharma, and he is in no way involved in the offense alleged in the FIR. He is neither an employee nor connected with the club Nirvana Resort in any manner. On the date on 15/7/2021, he only went to the said resort to pick up his wife, which he does on every day. For Abhishek, what else is your submission?
That's all, my lord. Nothing else.
Remaining other submission will remain same.
Otherwise also no way connected, my lord. It's just in the husband. And the
police remand, he was not sought for.
and he was not sought for a police remand also, my lord.
Degree on 21st.
21st. And in the bail objection, my lord, by the prosecution, my lord, regarding his, my lord, absolutely silent his involvement. Yesterday, when they filed the bail objection, my lord,
Learned counsel for the petitioner has submitted that on day before yesterday,
day before yesterday.
on 21/7/2025, when the accused persons were produced before the produced before the court of learned Chief Judicial Magistrate Kamrup Metro, the investigating officer, though sought for further police remand of
Four
other accused persons. However, no such prayer was made in respect of the present petitioner.
There is no indication of any involvement, my lord, in that.
Okay, that I have submitted. Next,
May I just add one line, Lordship? All the employees of the resort, Lordship, they have stated, Lordship, that he too is involved in the day-to-day functioning of the resort.
okay.
And then also, my lord, the recruitment does not come and
Okay.
143.
In public prosecutor submission একে থাকিব আগৰ নিচিনা এক line add কৰিব. The learned additional public prosecutor also submits that from the case diary, wherein the statement of the employees of the aforesaid resort were recorded under section 180 of BNSS, it is revealed that though the above named petitioner was not an employee of the said resort, he has been involved in day-to-day working of the resort.
These are family members, Lordship. Pawan Sharma is the uncle of the Abhishek Sharma, Lordship.
And he is the relative of the owner of the resort.
Even the residential address is also same, Lordship.
Okay. Now, item number gist of accusation baki একে থাকিব. Right. Mr. P.D. Nair, learned counsel, and this is item number 12. Learned counsel for the petitioner submits that the present petitioner had not booked any room in the Club Nirvana Resort. He only went there to stay in a room booked by accused number 1, namely Lalchan Hima Silo. And he further submits that the petitioner was not found either indulging in gambling or any other immoral activities, or in any manner linked with offense under section 143 of BNS. He further submits that only rupees. He further submits that though the FIR indicates that the seizure of items which are suspected to be used in gambling were seized from 3 rooms. However, it does not indicate specifically as to from which room what article were recovered. Stop. He further submits that only cash amount of rupees 22,000 was recovered from his wallet and which was never used in the purpose of gambling. Learned counsel for the petitioner also submits that in this case, the search of the rooms in which the petitioner was staying along with other co-accused was not made in pursuant to any authorization under Section 7 of the Assam Games and Betting Act 1970. Stop. He submits that in absence of any authorization or warrant for such search, such a search becomes illegal and cannot be relied upon to extend further custody of the petitioner. He further submits that the petitioner was not found gambling, not found indulging in gambling, and therefore the offense under Assam Games and Betting Act are not attracted against him. Any other submission?
There is no allegation against me, my lord.
Stop. Learned counsel for the petitioner also submits that as regards accusation under Section 143 of BNS, there is nothing against the present petitioner specifically mentioned in the FIR. Hence, the petitioner, learned counsel for the petitioner allows the praise for allowing him to go on bail. I will peruse the case diary and pass orders in chamber today. Case diary, give it to chamber. He get the bill.
If Lordship needs any clarification, I'm available.
Yes.
In compliance with the order dated 23/6/2025, my lord, petitioner sent in mail, my lord. Till now, I have nothing received from the authority, my lord.
What was the date?
Mail.
What was the date in the notice on, you received a notice under 35(3).
See, I have received, actually, my lord, one shopkeeper handed upon me, my lord.
One?
One shopkeeper of nearby the house of the petitioner, my lord.
What is the accusation?
You kindly see, page 13 is the summon notice, my lord. Page 14, my lord.
Where is the FIR?
No FIR, my lord. That notice has been received by the petitioner, my lord, which was issued by Superintendent of Police, my lord, CN Police Station, Bangalore, my lord. The petitioner paying for the transitory bail, my lord, transitory bail, my lord, for some particular period, my lord.
Why transit bail?
Lordship, I am relied on the free inferior judgment, my lord. Supreme Court.
Why you cannot go to Bangalore?
Proceed.
Why you cannot go to Bangalore and file your anticipatory bail?
He will file bail before the concerned, my lord, Session Judge or High Court, my lord, Bangalore, my lord.
No, why now you cannot go?
Proceed.
There must be some reason for approaching this court.
No, apprehending, my lord, that is case are registered, my lord,
No, my query is, you received a notice, you know that this is a case of Bangalore, within the jurisdiction of Bangalore. Why you cannot approach Sessions Court Bangalore or High Court Karnataka?
Proceed. Page 15, my lord. Last clause, my lord, J. Failure to attend, last mile, failure to attend the comply with this terms and notice can render liable to be arrested and others under section.
No,
30.
that I have understood.
My lord.
You have not understood my query. My query is, you received this notice when?
See, petitioner handed over, 140 were handed over, my lord.
When I am asking about date?
16/6/2025.
16/6, almost a month ago. What is the difficulty in going to Bangalore? That you have to mention. Have you mentioned in your application?
My lord. I have mentioned, my lord.
Where?
Page 5, my lord. Statement, my lord. There is some serious apprehension in the mind of the petitioner that in the event of his appearance before the investigation officer, he might be arrested and put behind the bar. In the event of he would be harassed, tortured, and shall be branded as a criminal.
No, that is not my query. You know that apprehension is there because of issuance of notice. You also know the proper court is Bangalore court. So there, Priya Indoria judgment says that there has to be a statement in your bail application, transit bail application, which narrates as to what is the difficulty. This court will consider whether your difficulty is genuine or not. If it finds the difficulty genuine, only then transit bail is to be granted. Transit bail may not be granted on mere asking for the same. You have received notice, you have approached this court. Priya Andoria judgment says that you have to satisfy this court what is the difficulty in approaching Bangalore court as of now. That statement has to be there.
Suppose you went there, my after proceed, some time will be required to collect the certified copies, my lord, and approach this session or High Court, my lord.
If that include that statement in your bail application, comply with the Priya Indoria's judgment, then we will consider your bail application. You have gone through the judgment on which you are relying.
103, my lord. Paragraph 103, my lord.
Yes, I am telling again. You file an additional affidavit mentioning what is the difficulty in approaching court of appropriate jurisdiction at this stage. Heard Mr. J. Laskar, learned counsel for the JUNM Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has prayed for allowing the petitioner to file an affidavit, file an additional affidavit to bring on record certain facts which are necessary for consideration of his transit bail application and which are also required to be there in such an application in pursuant to the guidelines laid down by the apex court in the case of Priya Indoria versus State of Karnataka and others, reported in 2024, 4 SCC 749. Stop. The prayer is allowed when let this bail application be listed after 10 days.
Item 16.
To move chamber paper দেখাবো স্যার না না লাগে না yes
Okay, sir. This is anticipatory bail application also. The FIR is at page 16. May I read you?
what is the offense?
The offense is under section 303, subsection 2 and 317 subsection 2 of the PMS.
What
and
is
11 of the prevention of cruelty of animals act.
where is the FIR?
The FIR is at page 16. It was filed by ASI Arup Kumar Deka, where he says that this is to inform you that today on 12/5/2025 at 10 a.m. on receiving an information through a phone call that cow thieves were on site at Doloni, Juria, along with stolen cows, which were halted with ropes and around legs and mouth of those cows inside a car. Accordingly, GDE has been made by Juria PS GDE number this dated this, and I, along with the following staff, left for the Doloni, Juria. In the meantime,
What is your name?
The Habibur Rahman, it has been alleged that Habibur Rahman accused number 1, 2, Ijazur Haq, and 4, Mukhtar Hussain. And the FIR itself, when it reads your Rashid, is very evident that the real accused person has already fled away from the place of occurrence. And they has been named FIR in this FIR, they have been named on some unreliable sources from the gathering public therein. Wherein your Lordship, you kindly find that the car that has been seized therein is also not the, they are not the owner. Neither the petitioners are the owner of the alleged car. And they were also not present in the place of occurrence. The page 18, your Lordship, I have annexed one of the vehicle details from the app where it is somebody of M. Rahman. The car belongs to some M. Rahman of Nogal district. And the cows were already been seized. The car is also been seized. And now, Lordship, for that reason, the custodial detention of this FIR name accused person may not be warranted, your Lordship, because they are not the owner of the car. Which
Why you have been named?
I have been named therein as petitioner accused number 1, 2, and 3. And the FIR itself, when it is read, it can be clearly seen that the accused person has fled away from the place of occurrence. And they have stated my name only from some sources of the gathering public.
Fled away that. Yes, Mr. Kekala.
Lordship, with the paragraph second, clearly stated that, Lordship, after local inquiry, 4 of the accused persons are identified, among others who are involved in steering car by using a 4-wheeler vehicle, Lordship. So, and I recovery is also there, Lordship, 4 cows. So their name is also there.
4 cows in one car. Inside a car. How it is managed?
Lordship, this is the cruelty, Lordship.
Now, whoever the
accused
person,
We will call for the case.
they should be apprehended, Lordship. They are not the person who had.
That is your submission, but you are heard, Mr.
I may be given an opportunity to file my statement before the IO, your Lordship, because his custodial detention is also not by
No relief now without perusing the case diary. Heard, Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Considering the acquisition made against the petitioner in the FIR, perusal of the case diary would be necessary in this case. Hence, call for the same.
14.
14. Can it be a shorter?
Many cases are there, Lordship, so I am fixing some 14, Lordship.
12.
10/17. So can it be on 10th? On 12th, I will not be present.
Okay, 10th August. It is on 11th August, miss. 11th. 10th is holiday.
On 11th, I will be not present also. Can be on somewhere on 9th or also. Then 17, 14 lordship. If he is not present. Because many cases are there lordship. Because see from 11 to 19, I will not be present your lordship. So
20.
lordship. Can it be on 8th your lordship?
No. 20.
Then also somebody else may appear. It may be fixed on the lordship has fixed. I will not be present. Somebody else.
Okay. 14th.
Item 17.
Maybe, my lord, in this petition, we have paid for transit anticipatory bill of sale. Lordship may kindly see the notice that is.
You have complied with Priya Indoria.
Yes, sir.
Why you could not approach the jurisdictional court? That statement is there.
Paragraph 5 is there. But, I am totally a layman to that state, lordship. The allegation.
No, whether that statement is there.
Yes, lordship. Paragraph 5.
So, Putul Priya Indoria.
Lordship, Yes. Paragraph 1996 is very relevant.
No. Where in your petition you have stated your difficulty?
Lordship,
Why you cannot go to?
Lordship, where I have.
Which court?
Here I have stated that since the case is registered under non-billable section.
That is not my query. Why are you not understanding?
Layman to that state, lordship. Because alleged offense.
Where is that? Where is that statement that you are a layman to that state?
That is their lordship. Here I have stated that I am from here.
You have to approach the court there.
Lordship. Lordship. I have stated that I am a permanent resident of the state of Assam, lordship. And the offense committed in the state of UP.
There has to be a statement in the petition disclosing your difficulty in approaching the jurisdictional court.
My submission may be recorded.
No, that is what Supreme Court has observed in Priya Indoria's case. You have to comply with the submit.
Apart from my difficulty is that is a non-billable section.
Not oral submission. You include that statement in your bail application.
I have stated that I am a resident of permanent.
That
resident.
is not enough. If you don't comply, I'll dismiss this. Not following the Priya Indoria's guideline. You follow the guidelines, go through the judgment properly.
Pick it up on Friday, I will file additional.
Yes. Heard Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned counsel for the petitioner, has prayed for allowing the petitioner to file an additional affidavit to bring on record certain facts which have bearing in consideration of the instant transit anticipatory bail application. The prayer is allowed. Let this case be listed on Friday. What is Friday?
It's 25th.
25th.
Item 18.
No, please, Your Lordship. Notice may go, POCSO 8 is there.
Heard Mr. B. M. Deka, learned counsel for the petitioner. Also heard Mr. K. K. Das. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 19th August.
Can it be preponed if possible, my lord? It's an anticipatory bill, my lord.
13th August.
My lord. Much obliged.
Item 19. Please, your lordship. Here in this case, my lord, is earlier rejected by your lordship, my lord, and the secretary bail, my lord. What happened, my lord? I have filing this application on the ground, my lord, that some annexures, which is important to this case, my lord, that was not annexed in the earlier bail application, my lord. In the earlier bail application, only FIR and the reject order of the learned court below was there annexed, my lord. But here, my lord, your lordship find the FIR page, my lord, 12, my lord. There is a assault between two parties, my lord. They are cousin brothers, my lord.
Whether charge sheet has not been laid.
Not been laid, my lord. And in the meantime, my lord, after your lordship's rejection, one person is surrendered before the police, my lord. And my lord, here, my lord, at this stage, my lord, what I am praying, my lord, there are 5 petitioners before your lordship, my lord. And petitioner number 5, my lord, he is a, my lord, son of petitioner number 1, my lord. He is aged about 18 years, my lord. He has just, my lord, got admitted in the degree first year, my lord. And he, as because he is the son of the petitioner number 1, my lord, his name also implicated, my lord. So, my lord, at this stage, my lord, his prayer may kindly be considered, my lord, only for interim protection, my lord.
His prayer was also rejected.
Also rejected earlier occasion, my lord. But
where is the rejection order?
Page 38, my lord. Page 38, my lord. There are assault between the parties, my lord. There are some injuries also, my lord. Page 38, my lord. Operating part from page 39, my lord. But in the earlier occasion, my lord, we have not annexed that there is a cross FIR from our side and there is a civil suit pending between the parties. All I have annexed in this bail application, my lord.
No, but that may not help you because it was rejected after perusal of the case diary.
That's true, my lord. But I am praying only for petitioner number 5, my lord.
On him also same is applicable.
My lord, there is a civil suit pending, my lord. Earlier bail application, those annexers were not there, my lord. That civil suit is there. We have lost the FIR that has not been registered. Thereafter, we file a complaint case before the CGM court, my lord. That also I have annexed, my lord. All are pending, my lord. Civil suit also pending, my lord. That filed by the informant, my lord. So, my considering that aspect, my lord, I am not asking for all the persons, my lord. Only that boy, my lord. As because he is the son of petitioner number 1, his name also implicated to harass the petitioners, my lord. They are all cousin brothers. Informant's mother, my lord. The petitioner's fathers are brother and sister, my lord. The quarrel is between them, my lord. Within the family, my lord. Own brother, my lord. The informant and the petitioner.
Case diary, when can you produce the case? It was rejected once, therefore.
Student, my lord, he got 84% marks in the
No,
my lord.
but it was rejected once. Therefore, perusal of the case diary.
Only that boy, my lord. For 7 days, my lord. Because the connected matters fixed on 30, my lord. 30, no? 30, it is fixed on 30, my lord. The other accused, my lord. For
Case diary has been called for.
Yes, my lord. That has been called for, my lord.
Heard Mr. S.M. Mullah, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This is for the second time the petitioners, namely 1, 2, 3, 4, and 5, have approached this court seeking anticipatory bail in this case. Their earlier application was rejected by this court on 16/5/2025 in AB case number 851/2025 after perusal of the case diary. Stop. Under such circumstances, perusal of the case diary would be necessary for consideration of the instant bail application.
Hence call for the same. When?
No.
On 30, let this case be listed again.
AB number 1484, my lord.
37, along with AB case number 1484/2020.
Can I pray for that boy, my lord?
No, no interim, because you know the reason.
Oblas, my lord.
My lord, here 10.21 gram of heroin was seized from one of my friend, my lord, who was present in my house at the time. So I've been also named because he was present in my house at the time to meet me, my lord.
Case diary would be done. Heard Mr. N. Anand, learned counsel for the petitioner. Also heard Mr. K.K. Das. Call for the case diary.
On
8th of August.
Item 21.
Please, your lordship. This is a pre-arrest bail application, my lord. Lordship will find the FIR at page 10, my lord, annexure 1, my lord. What happened in this case, my lord? The informant is the, my lord, wife of the accused petitioners, my lord, own nephew, my lord. And because of a wrong understanding and wrong advice, my lord, misunderstanding and a wrong advice, this FIR was lodged, my lord. However, my lord, they had a dispute, my lord. Social relation between the husband of the informant and the accused petitioner was not good earlier. And the,
Case diary would be necessary.
my lord will kindly have a look. The section, my lord, 64(1) may not be abstracted, but from the, my lord, bare perusal of the affair, my lord. Lordship will kindly have a look at the second paragraph, my lord, first paragraph, second line.
Section 8 of POCSO is there.
That I have seen, my lord, but why I am praying for, my lord, internal protection, my lord. There is a memorandum.
What is your name?
My lord, I am Z, no? And the petitioner is.
No, the petitioner's name.
Petitioner is, my lord, Dulaluddin. There is a memorandum of compromise also, my lord, between the parties, my lord. Page 13, my lord, that the matter has been amicably settled thereafter, my lord. After lodging of the affair, my lord, this matter has been amicably settled between the parties, my lord. My lord will kindly have a look at page 13, my lord, annexure 2, my lord. And I am very sure, my lord, when the informant will, my lord, appear, my lord, they will also, my lord, support my case, my lord. There are 4 clauses, my lord, in the memorandum of compromise, my lord. This is purely, my lord, because of a wrong understanding, my lord, wrong advice, my lord. This affair was lodged. At this stage, notice may be issued. Notice may go, my lord, and my lord, I may be protected, my lord, because, my lord, this dispute is, my lord, in between the own family members, my lord. Nobody else is there, my lord. Purely because of, my lord, wrong advice and misunderstanding, my lord, this affair was lodged. And the girl, my lord, was sent voluntarily to the house of the accused petitioner, my lord. From the perusal of the affair itself, my lord, it speaks, my lord, that the girl was sent by the parents, my lord, to sleep in the house of the accused petitioner.
But that may not be a reason for
Yes,
subjecting.
I understand, but so far as the memorandum of compromise is there, my lord, she will kindly consider that part, my lord. And I'm very sure that they will support this memorandum of compromise, my lord, when they will appear, my lord. The informant will appear, my lord.
No, we do not know about the veracity of this
Yes,
compromise.
therefore, my lord, I'm very sure, my lord. And I'm hopeful that when the informant lady will appear, my lord, she'll definitely, my lord, submit on oath that this memorandum of compromise was executed between the parties, my lord.
Let her appear.
Until then, my lord, she will kindly protect me, my lord.
What is your age?
My age is 61, my lord.
No protection now. She has to appear.
She'll appear, my lord, she will kindly consider me.
No. Heard Mr. Z. Hamad, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Since offense under POCSO Act is involved in this case, issue notice to the respondent number 2 and call for the case diary. The petitioner shall take steps for issuance of notice upon respondent number 2 within 3 days from the date of this order, returnable on
13th of August.
13th of August.
Sir, this is from Morigaon.
Okay, 13th of August.
Till then, my lord.
No.
I'll leave it to lordship.
List.
Deeply, my lord.
62. None has appeared for the petitioner on call. List this matter. Yes.
Angus Council is like in another post. For finally the listing would time being also.
Okay.
After 2 p.m.
My lord, it is a substituted matter, my lord. Kindly all for the, my lord, scan copy of the case record. My lord.
No, charge sheeted matter, POCSO case,
My lord, wildlife.
wildlife. Why the bail is rejected by the trial court? We'll take it up. Let him come. Who will be coming?
Each or one.
Let him come. The council come.
Bail application, my lord. Before my friend starts, my lord, one thing is that, my lord, here I have gone through the record. The record is up to 21/1/25. Till then, 4 witness examined, but subsequent to that, my lord, it is updated scan copy is not.
My lord, I am on the ground of arrest, my lord, notice, my lord. That has no ground of arrest in the notice under section 50 and 50A, my lord. So record is here, lordship. I'm only on that, my lord, because not on merit.
What is the offense?
Offense is my commercial quantity, my lord. Some cough syrup bottle and capsules were recovered from the house of the petitioner, my lord. I'm not on merit, my lord. On that ground, I have, my lord, praying, my lord. If record has come, my lord, that notice under section 50 and 50 will be there, my lord, in the report.
Yes, go through, Mr. Parash. We'll take it up after some time. Let him go through.
This is an application under section 483, my lord. POCSO, my lord, allegation. And the accused, my lord, behind the bar since 330 days in custody, my lord. 5 numbers of PW witnesses has already been examined, my lord. And basically, my lord, victim, my lord.
Victim has been examined.
Examined, my lord. Page 31, my lord. I have annexed the evidence, my lord. There is a love affair between the parties, my lord, victim and the accused, my lord.
Then what happened?
Yes, my lord, they eloped, my lord. Marriage has been happened, my lord.
Detained behind the bars since 27/8/2024, within bracket, for last 330 days in connection with special sessions case number 265/2024 under section 363/366 of the Indian Penal Code, read with section 6 of the POCSO Act, 2012. Pending before the Court of Learned, Additional Session Judge cum Special Judge POCSO, Kamrup Metro, Guwahati. The gist of accusation in this case is that the petitioner is facing a trial before the Court of Learned, Additional Session Judge cum Special Judge POCSO in sessions within bracket special case number 265/2024 under the aforesaid provisions of law, with an accusation that he subjected the victim girl to sexual intercourse, as a result of which the victim, he further submits that in the session special case number 265/2024, trial has progressed substantially, and Out of how many witnesses?
Seven, my lord. Five
Out of
witnesses.
7 listed prosecution witnesses in the charge sheet, 5 have already been examined. Stop. The victim girl as well as the petitioner as well as the informant were also examined. He therefore prays for allowing the petitioner to go on bail, considering the progress made in the trial as well as period of detention of the petitioner. Stop. On the other hand, Mr. B. Sharma, you're opposing? B. Sharma has learned additional public prosecutor has submitted that though the victim girl has been examined, however, there are incriminating materials against the petitioner in these depositions of the prosecution witnesses who have already been examined. And there, stop. Mr. S.K. Chetri, learned counsel, your counsel, English counsel, learned counsel for respondent number 2 and 3 has also opposed the grant of bail of the petitioner on the ground that there are sufficient incriminating materials against the petitioner in the case, on record in this case, and the victim being a minor has also delivered a baby. What is the age of the victim?
18 years.
18.
18 years.
At the time of occurrence, 17.
17 years, 6 months, 26 this month.
Yes.
In this case, the petitioner, he was arrested on 10/9/2024. And charge sheet has been submitted. And I got 2 tests earlier examined, and recently another what has been examined. Altogether 3 tests have been examined. Victim was examined, and the informant was already expired.
How old is victim?
Victim was at the time of incident, he was
13 years.
13 years.
I am inclined to grant bail, but if this judgment puts any embargo, then I will go by this judgment.
Then in our next each and every case, that will be applicable.
No, that I will examine.
My friend also cannot come also.
You are threatening him.
No, concerning I POCSO case, I will appear. No.
May I please your lordship? I beg to mention item number 56. My senior is out of station, so kindly adjourn the matter for the day.
Request of learned counsel for the petition. What is your name?
A Parasar.
Miss A. Parasar, learned counsel for the petitioner. This matter is adjourned for the day. List
Kindly fix on Monday.
this matter on. You are on interim bail on 19th of August. This
56.
The interim order shall continue till next day.
Item 25.
This case for CD also not.
Issue reminder for the case diary. Yes.
My pleasure, Lordship. It's equal to Lordship Commercial Quantity of NDPS Act, Lordship. Basically, Lordship, the on ground that, ground of arrest is not furnished, Lordship, that is my ground proceeding being. Some tablets were recovered from the position of the petitioner.
What
and
is,
Thereafter, he was arrested, and the grounds of arrest was not furnished in the 47 and 48, should be honest.
yes,
I have perused the record, Lordship. Here, Lordship, I have tag marked that, Lordship, section 47 and 48 notice, Lordship.
is it there?
Lordship, in the record, Lordship.
Whether grounds are mentioned?
That is the Lordship that mentioned.
This 47, Lordship, that 2 lines, Lordship, you are hereby informed that you are arrested in connection with FR above noted case, so this is that.
It is your submission.
And
Regarding.
And 48 also, Lordship, this must on. I have any division of the in the record also, in this campaign.
Also, regarding ground of arrest, Lordship, here in this case, Lordship, Lordship may kindly peruse one flag is there, Lordship, that the court on the day of his production, Lordship, that court order is there, Lordship. And in that order, Lordship, he has stated, Lordship, that on asked, and the accused has stated that his family member is aware about his arrest and they will engage counsel for him. That is their Lordship.
But that does not absolve the prosecution from the duty of furnishing grounds of arrest.
Yes, Lordship. Therefore, Lordship may kindly also see, and the may also peruse, Lordship, that also even in seizure list also, that has been recovered from his house, materials has been recovered from his house, Lordship. So, Lordship, in the main article 22.1, even in article 22.1, it is not says, Lordship, that he should be, he should be informed under section 47 or 48 or 50-51, Lordship. It is that, Lordship, the mandate is that, Lordship, he has to be informed why he has been, the ground of arrest has to be informed, Lordship.
Whether you have informed.
Lordship, because, Lordship, it is not in the article 22.1 also, Lordship, it is not nowhere mentioned, Lordship. So that has to be in written form, Lordship.
That has been clarified by Apex Court.
Apex Court, Lordship. Because, Lordship, in Lordship, because that Bihan Kumar's husband has come in the February 2025, Lordship. And prior to that, Lordship, I may produce punish, Lordship, some judgments, Lordship. That's wherein it is stated, Lordship, that even if the ground of he has been told, then also article 22.1 is complied with.
With judgment.
Lordship. I will please do first two judgments, Lordship. One is, Lordship, first, Lordship, in A.K. Gopalan case, Lordship, 1950. Here, this is 6 judges bench, Lordship. And here also, Lordship, it is nowhere in, this is the constitutional interpretation, it is known to all, Lordship, that constitutional interpretation is there, Lordship. So in here, Lordship, in para 350, Lordship. Probably page 424, Lordship. Page 424. Para 350.
Yes.
Lordship, here, Lordship, clause 1 and 2 of article 22 lay down the procedure that has to be followed when a man is arrested. They ensure from 4 things: right to be informed regarding ground of arrest. The first is right to be informed regarding ground of arrest. Right to consult and to defended by a legal practitioner of his choice. Right to be produced before a magistrate within 24 hours. Freedom from detention beyond the said period except by order of the magistrate. So here, Lordship, here it is not stated that he has to be, that ground of arrest has to be in written.
You have brought a 1950 judgment.
Lordship.
To
Lordship.
Later on, Supreme Court has clarified that it has to be in writing.
Lordship, because, Lordship, this is a 6 judges bench, Lordship. So, Lordship,
So is there any mandate in this that it has not to be in writing.
Okay. I am coming to other judgments also. Here in this case, Lordship, when because Lordship, the entire issue has arisen only because of the judgments, Lordship. And we are not that because it is a old judgment. This is a 1950s judgment.
No,
So,
where it is mentioned that.
Lordship, here here mentioned right to be informed.
Yes.
That is, here it is not nowhere mentioned that Lordship he has to be informed in writing. So here subsequent judgment I'm going to place Lordship, that is Lordship 1966 AI 1966 1910 page.
Yes.
Here Lordship para 20 first Lordship. Para 20 Lordship.
No, in A.K. Gopalan, what has been stated is what is already there in Article 22(1), that grounds of arrest are to be informed. Have you informed?
Lordship, we have informed Lordship.
Where?
That is the section 50 notice Lordship.
In section 50 notice, there are no grounds.
Because Lordship, that is because there is no mention Lordship that the ground of arrest, how it has to be mentioned, in how it is to be clarified.
No. Understand my query. If it is not to be in writing, your submission is that it has to be in some form. How you have informed? You are saying that you have informed by giving 50 notice only.
Because Lordship, subsequently I am coming, that is why I am coming to the next judgment.
No, before you go to next judgment, you clarify how you have informed in this case, grounds of arrest.
That Lordship section, first Lordship section 50 notice is there Lordship.
Merely by giving a notice and writing there on that notice that it is notice under section 50, would it be sufficient to comply with the?
Apart from that Lordship, when a person is arrested, when a person which caught red-handed, when some articles are recovered from his house.
So it is your submission that if a person is arrested red-handed, there is no requirement of following the constitutional mandate.
No, sir.
Then what is your submission?
Because Lordship, at the same time, Lordship, his that requirement is fulfilled, Lordship. Because Lordship, sometimes Lordship, when person is arrested, apuna kyo arrest kora hol? That is the simple first question. Why police? Why I have been caught red-handed?
No,
why I have been arrested?
No, Mr. Locker. His submission is that in this case, constitutional mandate of 22(1) has not been followed, as because the 50 notice does not contain any ground. Your submission is that it has been followed. You have to show how it is followed.
Lordship, that is why Lordship, I am submitting Lordship. That Lordship, when a person is arrested, he is being told, because Lordship, that court order is says Lordship. That court order Lordship may kindly pay us.
Which court order?
That I have take mark it Lordship. The first day, the day of production is Lordship. Here Lordship, he has been stated when he himself has stated Lordship that his family persons are known, aware about his arrest. They will engage Lordship.
Which order you are referring to?
That I take my Lordship. That in fact,
No, let him submit. Let him submit.
Every order.
No, let me see that order.
Order of the trial court, Lordship, court order is take as
Yes, what it says.
that I have underlined also. Because as per Bihan Kumar also Lordship, as per the Bihan Kumar judgment also, the last paragraph 3 number and Justice Honorable Justice Anticipatory Singh's order Lordship, it is stated Lordship that the requirement of the motive of Article 22(1) is not to only to give grounds of arrest. So it is the motive is that Lordship, so that he can engage one counsel to defend himself, defend him. The motive is that Lordship. when person that when motive is fulfilled, Lordship, when person is aware that he has been arrested, his family members are, and in this case, Lordship, on the next day, Lordship, on the next day, legal aid council has been engaged in this case.
So what do you want to say?
My submission is that, Lordship, when person is arrested, Lordship, caught red-handed, Lordship, from his house, now a big quantity of some articles, NDPS articles is being recovered. He himself is aware about his why he has been arrested.
Therefore,
even though, Lordship, even though, Lordship, when he has been served a notice that you have been arrested under NDPS Act, Lordship, that itself that it fulfills the criteria of Article 22(1). And even, Lordship, prior to the Pankaj Bansal case, Lordship, it is yes, it is after Pankaj Bansal, Lordship. Even Pankaj Bansal has stated, Lordship, that prior to R.K. Arora, Pankaj Bansal has stated that prior to that, Lordship, there is no requirement of ground of arrest in writing, Lordship. Then, Lordship, why if it is so, Lordship, then there is no requirement of article giving notice in writing. Then also, if the article fulfills, mandate of article fulfills, then why after Bansal giving that notice is not fulfilling the mandate of Article 22(1). Prior to that, when Honorable Court is Honorable Apex Court has itself stated that prior to that, if notice is not served in writing, then also it is not fatal. It is not.
Now, what is your submission?
So my submission at this stage is, Lordship, that article when person is arrested, caught red-handed, he has been served the notice here. Thereafter, Lordship, in Lordship will find, Lordship, that section 50 NDPS notice, Lordship. There also that section is mentioned specifically that you have been arrested under NDPS Act, specifically mentioned. Thereafter, Lordship, from the seizure also his signature is there. That, Lordship, that articles has been seized from him. He is fully aware about why he has been arrested. It is not that only specifically not mentioning why you have been arrested, that what it would be written, that articles has been recovered from your house, that only because of that, not specifically mention that few lines, that the article, we may not say that, Lordship, that Article 22(1) is not complied with. Because, Lordship, apart from A.K. Gopalan's case, thereafter, Lordship, what I have submitted, Lordship, 1996, Lordship. So what I'm case, Lordship, this is also 5 judges bench, Lordship. Here, Lordship, it is if he is being told, then also it is fulfilled, Lordship.
No, that is my query. Where have you told him?
On the day of issue, Lordship.
Where is that?
That, Lordship,
how will you prove it that you have told him?
Because, Lordship, from his arrest, Lordship, because we have because, Lordship, when we
suppose you have arrested somebody and have not furnished him grounds of arrest, furnished him either notice, neither you have told him why you have arrested, you have arbitrarily arrested an innocent person. How will you differentiate?
We will go by the order of the, because, Lordship, if we do not inform him, then, Lordship, that production on the day of production, the trial court will verify, Lordship, because in Bihan Kumar also, Lordship, it has to be verified by the trial court, Lordship. In that case, Lordship, trial court will verify, Lordship, whether that 47 notice, 50 notice is given or not.
Suppose you give a blank sheet of paper.
Trial court will
Listen to my query. You give a blank sheet of paper, write on the top of it, notice under section 50 CRPC, to so-and-so accused. Will it satisfy the requirement of?
Because, Lordship, they are in because even our section 50,
Okay.
section 50 also says, Lordship. Section 50 also says, Lordship, if the offense has to be mentioned there or ground of arrest. Section 50(47) also says, Lordship, that that has to be informed the offense or ground of arrest. Offense for which he has been arrested or ground of arrest. It is not an end ground of arrest. Even though, Lordship, when, Lordship.
So is it your submission that if you mention the offense, grounds of arrest need not to be mentioned? I want to know what you intend to submit. Is it your submission that if you mention the offense, there is no requirement of mentioning the grounds of arrest?
Lordship, my submission, Lordship.
Yes or no? Is it your submission?
Lordship, I cannot say, Lordship, because on.
No, you have taken so much of time, but you have to.
So it is not like said later, so I'm trying to submit something, Lordship, before Lordship.
Be clear on what you are submitting.
That is well, I'm.
Therefore, I'm putting so many queries.
Going to, I'm facing the judgment also, Lordship. Lordship may kindly peruse, Lordship, that sovereign judgment, Lordship. What does it say, Lordship? Because this is also 5 judges bench, Lordship. Para 20, Lordship. Para 20. M. Hidayatullah, Justice M. Hidayatullah judgment. There para 20, Lordship.
Yes.
Article 22(1) is 2 parts and it gives 2 persons arrested a twofold protection. The first is that an arrested person shall not be detained in custody without being told the ground of such an arrest, and the other is that he shall be entitled to consult to be defended by a legal practitioner of his choice. So, Lordship, without being told the ground of such an arrest, and the other is that he shall be entitled to consult with the consult and to be defended by a practitioner. So here also told. Therefore, also may see para 22. It is more clarification.
Yes, what it says.
I consider that there is a room for further deliberation on the point. I do not see how we can differentiate between arrests of different kinds. Arrest is arrest, whenever, whatever the region. In so far as the first part, Article 22(1) is concerned, it enacts a very simple safeguard for persons arrested. It merely says that an arrested person must be told the ground of his arrest. In other words, a person's personal liberty cannot be curtailed by arrested without informing him as soon as is possible why he is arrested. Where the arrest is by warrant, the warrant itself must tell him. Where it is by an order, the order must tell him. And where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all that the first part of Article 22(1) is lays down. I find nothing in Article 22(1) to limit the requirement to arrest of any particular kind. A warrant of a court and a warrant of any authority must show on which there face the region of arrest. Where there is no such warrant or order, the person making arrest must inform the persons the region of the arrest. In other words, Article 22 means it is says in first part. They are the 24 Lordship.
Yes.
As I have stated already, a person who is arrested gets 3 rights which are granted. The first is that he must be told why he is arrested. This requirement cannot be dispensed with by taking bail from him. The need to tell him why he is arrested remains still. So also here also why he has been arrested. That it must be told. He must be told why he has been arrested. Therefore, Lordship will
how it helps you?
It helps Lordship me, Lordship that Lordship when person is being arrested, he is being told that you have been arrested. When? Because he has been served with a notice.
Okay.
He has been served with a notice.
Okay, Mr. Lakar, what you do, you submit a written gist of your argument so that I can address each of your concern in the order. Third, Mr. S. Munir, learned counsel for the petitioner. Also, Mr. P.S. Lakar, learned additional public prosecutor. This bail application has been moved by the petitioner mainly on the ground that at the time of his arrest, though notice under section 50 of notice under section 47 of BNSS was served on him, it does not contain any grounds of arrest. Ground of arrest. So he also submits that even the notice under section notice under section 48 of BNSS does not contain any ground of arrest, and therefore there has been a violation of the constitutional mandate under Article 22(1) of the Constitution of India. However, whereas Mr. P.S. Lakar, learned counsel for the petitioner, has submitted that the petitioner was caught, the contraband was recovered from the house of the petitioner, and he was served with the notice under section 50 of section 47 of BNSS at the time of his arrest. And there has been no violation of the constitutional mandate as provided under Article 22(1) of the Constitution of India. In support of his submission, learned counsel for the petitioner, learned additional public prosecutor, has cited a ruling of the Apex Court in the case of A.K. Gopalan versus State of Madras, reported in 1950 SCC 228, as well as another ruling of the Apex Court in the case of
State of Maharashtra versus Madhya Pradesh.
State of Madhya Pradesh versus Shobharam, Shobharam and others, reported in which is this?
AR 1966.
AR 1966.
SC 1910.
SC 1910. Stop. After considering the submission, the submission of learned additional public prosecutor, this court feels that the points raised by the learned additional public prosecutor are required to be addressed while disposing of this instant bail application. Hence, Mr. P.S. Lakar, learned additional public prosecutor, is requested to submit a written gist of his argument. When will you, sir? Within a week.
On 29 or so.
On 29/7/2025. List accordingly. Yes. Let him submit. You can respond to it that he has raised.
Is a mandate lordship.
No, let him. No, I have heard both of you. If you submit, give a copy to the counsel for the petitioner with a
That may be reflected.
one. The learned additional public prosecutor is also requested to furnish a copy of his written gist in advance to the learned counsel for the petitioner, so that if required, he may respond to the same. List accordingly.
Much obliged.
Item 26.
Judgments which I will place in that.
Yes, in your written gist, you can include anything.
Same proposition, page 34. Notice 1. 47 notice, page 34.
In this case, lordship CD was called for, that we have not received the CD lordship.
Page.
Earlier case, kiman tarikh dilu?
29.
Today is Let it be shorter date. On 25 you submit.
Day after tomorrow.
Day after tomorrow. Only gist.
28th or
No. I have heard you. Otherwise, I don't require written gist. I am asking for it only so that what you have submitted should be on record from your side. Only for that purpose I want it. So let it be on 25th. Munirok, SM Munirok. 25. Yes. See, case diary would be required.
My lord, what happened, my lord? Maybe, my lord. Lordship, now probably, my lord, case lordship has to call for the LCR.
LCR also.
Yeah, my lord, from the additional session judge, Lakhimpur, because the charge sheet has been filed during the pendency of this. Appeal, bail, my lord.
Okay, heard Mr. A.M. Bora. 20B2 charge sheet has been filed under what provision? Commercial quantity is involved.
Yes. 20B.
2C.
NDPS. Yes.
Okay, heard Mr. A.M. Bora, learned senior counsel, assisted by Mr. B.H. Chaudhary. R. Bordoloi. Borthakur. R. Borthakur. Learned counsel for the petitioner. Also heard Mr. P. S. Laukar, learned additional public prosecutor. This learned senior counsel for the petitioner submits that the charge sheet has been laid in this case. Stop. Considering the submissions made by learned, charge sheet has been recently laid. Just when it has been laid, you do.
$23. Okay. 23/4/25.
23/4/2025.
Charge sheet number 60 of it.
Bearing charge sheet number 60 of
2025.
2025.
In special NDPS case number 23/2025. The Court of Additional Session Judge, FTC, Lakhimpur.
Stop. Let the scanned copy of the trial court records along with the scanned copy of the case diary of Laluk PS case number 208/2024 be called for from the trial court. The registry to issue requisition for the same. Let this matter be listed. Putul. See case diary. No. 11th of August.
Item 27.
Yes.
The section concerned minute here, the statutory period is 90 days. And today is 91 days, madam. Is behind the bar. And initially the case was registered under the merits of PS in the district of Bongaigaon and subsequently transferred the case to Toraidev in the district of Sonitpur. At present, he is under the
Charge sheet has not been laid.
It is there.
What is your submission? Statutory period is over. Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, as well as Mr. S. Nawaz, learned amicus curiae appearing for the respondent number 2.
this application under section 483 of BNSS has been filed by the petitioner, namely Musa Ali, who has been detained behind the bars since 24/4/2025, within bracket for last 91 days, in connection with Merar Char Police Station case number 18/2025 under section 137 within bracket 2/127 within bracket 2/103 within bracket 1/3 within bracket 5 of BNS, read with section 4 of the POCSO Act 2012. Learned counsel for the petitioner has submitted that for the offense involved in this case, the maximum prosecutor has also submitted that, has produced the case diary of Merar Char PS case number 18/2025 and has submitted that the investigation has not yet been completed and the statutory period of detention is over. Same is the submission made by London. Yes.
Sorry, Lord. It is transferred to Saridwar, it's 4/25.
The
Just now.
PS case number has been changed.
Lordship, it is transferred to Saridwar.
Stop. Additional public prosecutor has also submitted that the Merar Char PS case number 18/2025 has been transferred to Saridwar Police Station and has been re-registered as
Saridwar, PS case 84/25.
Saridwar PS case number 84/2025. Stop. Learned amicus curiae for appearing for respondent number 2 has also submitted that it appears that the statutory period of detention is over in this case. Considering the submissions made by learned counsel for both sides, as the petitioner has already completed the statutory period of detention, he is allowed to go on bail of rupees 30,000 with it is rape and death. Rape and death.
What happened, due to law of defection, both are minor. That means boy is not eligible as 20 years old.
28 CD not available.
Lordship, the today is this 74 days, Lordship. In PA Act, Lordship, the other co-accused already gained bail on the 55 days, Lordship. Only suspected, Lordship, the alpha link man, Lordship, they arrested.
Alpha link man.
Yes.
When will you produce the case diary? Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing the case diary.
Because it was earlier CD
Prays
was
for
there.
producing the updated case diary. Prayer is allowed. Let this case be listed.
29 Lordship on 1st August.
1st of August.
It's already 74 days, Lordship, co-accused grant bail.
1st of August.
29, Lordship, earlier.
No.
Item 29.
Very police also, much one.
My lord, after going to the fire, my lord, my understanding is that not it's a case of my lord child marriage, my lord. My lord, page 12, my lord, is a FIR, my lord. Marriage, my lord, is a vernacular, my lord.
No, what is the submission?
So page 12, my lord, is the FIR, my lord. Married, my lord.
Yes.
What, my lord? সন্মান সহকাৰে মহোদয়ক জনাও যে যোৱা ইংৰাজী 12/5/2025 তাৰিখে
কম বয়সীয়া কন্যা শ্ৰীমতী চৈঞ্চ বয়স 16 বছৰ দ্বিতীয় পক্ষই নানা ধৰণৰ চক্ৰান্ত কৰি পলুৱাই লৈ
Item 41. In this case, my lord, LCR was called for, my lord, and it seems, my lord, it has not been received, my lord. One more, my lord, reminder.
Heard Mr. N.J. Datta, learned counsel for the petitioner. The records of the trial court have not yet been received. Stop. Issue reminder for the same. Registry to issue reminder. Registry to take steps for issuance of reminder.
Can it be on the 1st of August, my lord?
Let this case be listed on 1st of August.
Not bad.
Item 42. Hearing, madam, Mr. Dikshit Google was appointed as amicus. I had informed him earlier, but I'll take it up after some time. Again.
Item 43. Your lordship, my lord. Arrested on 16/3/2025. FIR is at page 15. And the driver and the handyman. Suspected Yaba tablets.
When have you arrested?
16/3/25. My lord, I have filed an affidavit. Your lordship may look at peruse the affidavit, page 36 and 37. In affidavit, your lordship may look into page 36 and 37.
Yes.
Your lordship has perused the affidavit, page 36. Grounds of arrest, 48 BNSS. My submission is, my lord, relying on, my lord, I think it's para 30, my lord. My lord, para 28 and 29 of the COVID POCSO case, 24/8 SCC 254. 24/8 SCC 254. My submission before your lordship is page 36. That is notice of information of grounds of arrest, 48 BNSS. In place of grounds of arrest, left-hand side, they have given the reasons of arrest. And my lord, if your lordship may look into the paragraphs of
What has been stated?
the FIR named accused Samiruddin such and such offense committed suspected Yaba tablets for transportation illegally. These are the reasons for arrest. These are not cannot be the grounds, but I have given a judgment. Para 28/29. Two petitioners are there, and at page 37 also the same. Para 28, my lord.
Yes.
And my lord, the distinction between my lord, grounds of arrest and reasons of arrest are also there. My lord, your lordship will find para 28, the language of article 22(1) and 25 of the Constitution regarding communication of the ground, exactly the identical. Neither the constitutional provision requires the grounds of arrest or detention of the case movie must be communicated directly. Thus, interpretation to this important phase of the fundamental rights as made by the Constitution bench while examining the scope of article such and such would effect apply to article of the Constitution insofar as the requirement of communication of grounds is concerned. Hence, we have no hesitation to the requirement of communication the grounds of arrest and ground of detention attached connection such and such provided at article 22(1). And my lord, I will take your lordship to other. Article 22 is sacrosanct and cannot be breached under any situation, and non-compliance with the constitutional requirements statutorily amended. Now I take your lordship to the distinction between the grounds of arrest and, my lord, the reasons for arrest. That is at page para 37.
Yes.
36 and 37, my lord, if I can please it. The learned single judge of the High Court Delhi held at SCC online in impugn order. The respondent had taken a categorical stand that the grounds of arrest were informed to the appellant orally. In the same way, also conveyed in writing as per the details set out in the memo of arrest. However, the learned ASG fairly did not advance any such argument based on the arrest memo. The interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing while the arrest memo is unacceptable on the face of the record because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column 9 of the arrest memo, such and such, which is being reproduced herein, simply sets out reasons for arrest, which are formally in nature and can be generally attributed to any person arrested on accusation of an offense, where the grounds of arrest would be personal in nature and specific to the persons arrested. Next, reasons for arrest. Prevent the such as for committing for further investigation offense. These are what the reasons for arrest are there. Next, para 38. The remand order records that the copy of the remand application have been sent to the learned advocate engaged by the appellant accused through WhatsApp. A bare perusal of the remand order is enough to satisfy us. These two lines were subsequently inserted in the order because the script in which two lines were written is much finer as compared to the remaining part of the order. And moreover, these two lines clearly indicate subsequent insertion. It is quite possible learned remand judge may have heard the learned counsel of the appellant after signing the remand order. Thus, lines were inserted later through intending harm or malintention, but the fact remains the order of remand had already been passed such and such. That is a different question. Now, the only reasons, the difference between reasons for arrest is at page para 48. Para 48. May I read it, madam?
Yes.
It may be reiterated at the cost of repetition. There is a significant difference in the phrase reason for arrest and grounds for arrest. The reason for arrest, as indicated in the arrest memo, are purely formal parameters to prevent the accused persons from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on a charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigation officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are general in nature. This is my submission, Bharat, because your lordship may look into
Now, what has been mentioned in the notice?
Notice grounds of arrest.
Read.
Page 36. The grounds of arrest they have written. The FIR named accused Samiranuddin Beg committed the offense of the criminals of criminating suspected Yaba tablets for transportation illegal. This is reasons for arrest.
No, this is not reason for arrest.
And the next page, my lord, the accused person.
You are found in possession of Yaba tablets and therefore you were arrested.
A driver and a handyman. It was found in the vehicle.
No.
Vehicle belongs to somebody else.
You may counter what has been informed to you, but it has been informed that you were found in possession.
Possession. But my lord, possession doesn't mean my lord 22 one will go away. And this paragraph of 48 has made a distinction between the reason of arrest and the grounds of arrest. Reasons of arrest, my lord, with your lordship permission, my lord, I am reading it again, my lord. The reasons for arrest.
Purpose. Reasons for arrest. The apex court has distinguished to prevent you from committing for further investigation.
My lord. And my lord, I take your lordship in my affidavit, the arrest memo. Your lordship will find.
No, we are concerned with the question whether the information provided against the column grounds of arrest
Whether it is
grounds of arrest or not.
What is the grounds of arrest? It has been stated. whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer, which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts.
So in this case, the basic facts were you were found in possession with.
Those, at least that should have been there. It's not there. At least that should have been there.
No, it is there.
My lord, it is said the FIR named accused committed the offense. That is the reason why I am arrested. I have committed this offense. That is why I am arrested.
Of carrying suspected
Yaba tablets for transportation illegal. This is the reason. It cannot be the grounds of arrest. That is my submission in pursuit to this judgment, madam. Para 48.
Yes.
The ground of arrest, Lordship, it is specifically stated that why he has arrested, Lordship. Conscious position, it is also written here, Lordship. Otherwise, he will engage in law advocate, Lordship. He will argue the case. Argument is not at that point, Lordship. He is about to inform why he was arrested. It is everything is there, Lordship. Why he was arrested, Lordship. And detailed grounds for such arrest. And it is also there, Lordship, why he was arrested.
Where?
Suspected NDPS website, Lordship.
Where?
Lordship.
In page 36.
Page, Lordship.
36.
I'm sitting from CDA, Lordship.
Page 36. Page 36. It is being to afford. Notice of information of ground of arrest 48 BNFS.
Okay. Heard Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Give me the case diary. I'll retain it. Day after tomorrow. Let this case be listed for delivery of orders on 25th of.
In my submission, Lordship, it is complied with.
Okay.
Obliged, ma'am.
Item 34.
Maybe. Also, this petitioner is behind the bar, Lordship, since 2nd of July 2024. More than 1 year from Lordship. In Chasita's case, Lordship, trial is going on.
On what ground you are seeking bail?
Lordship, because the trial is already there, prosecution has examined as 4 witnesses, and I have annexed the evidence adduced by the 4 prosecution witnesses. Lordship will find the evidence. And there is nothing to, Lordship, convict this person under section 20C. So this is basically the ground, Lordship.
How many witnesses are there?
Independent witness, only 2 is there, 2 are there. They are
Total how many witnesses?
it is 9, sir. All the official witnesses.
9 out of 9, 9 or 5.
I have annexed 4, Lordship. If it is 5,
Till 5, 6, 25, 5 witnesses. Till 5, 6. 6,000 Yaba tablet and FSL is methamphetamine it is.
So I have annexed the lawsuits, the evidence of all four prosecution witnesses. And there is nothing except the informant lawsuit. Other lawsuit prosecution has witnesses has not implicated this person lawsuit.
Who has implicated?
Only the informant lawsuit.
That is, that,
Yes. Informant has lawsuit, I have mentioned in my petition also, informant has some personal grievance against this petitioner.
that plea cannot be taken now. Whether the evidence has to be relied on or not.
Except informant lawsuit, other prosecution lawsuit will see the independent interest as you have mentioned.
How will you overcome 37 embargo?
37 number lawsuit, 37 will not attack this person because there is apparently there is no materials to lawsuit convict this person under section 22C. So
Yes.
if lawsuit only because of that there are 4 or 5 witnesses remaining to be examined. If that is the grounds of prosecution lawsuit, it is lawsuit definitely lawsuit violate the right fundamental rights of this person because there is other prosecution witnesses not implicated these persons. So kindly see the statement of two independent witnesses.
No, we cannot be choosy. You cannot pick evidence which is in your favor at this stage.
That's two laws. That's why I cannot lawsuit separate the part which implicates this person and who is not implicating the person.
At this stage.
Yes. But thing is that lawsuit, I may be lawsuit, at least lawsuit proceedings, most half of the lawsuit proceeding has been lawsuit over. 6 has been examined.
No.
And out of these 6, only the personal informant who has some personal lawsuit enmity with this petitioner. I have mentioned in my petition also. What is the enmity of this informant with this petitioner? So that lawsuit only because of lawsuit that 6 some persons are remaining to be examined. If that is the plea lawsuit, kindly consider the evidence adduced by the other witnesses, independent witnesses.
Yes, Mr. Parash.
Yes, till now, 4 witnesses yet to be examined, and evidence against him may come by the evidence after the recording of the evidence of this 4 witnesses, may be official, and in case of official witness also, conviction can be granted,
Heard Mr. J. Kalita, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Noor Hussain Sheikh, who has been detained behind the bars since 1/7/2024, within bracket for more than 1 year, in connection with special case number 572/2024 under section 22C, under section 22C of NDPS Act 1985, presently pending before the learned Special Judge Dhubri.
That's why we will dispose of this case. Well, let's defer for up-to-date lawsuit.
No, I'm dismissing it.
Lawsuit may take up next idea lawsuit Monday.
No, why?
So only one opportunity may be given because lawsuit already the 5 witnesses have been examined. None of them lawsuit has been implicated this person.
No, I'm addressing your submission.
Yes, but thing is that lawsuit only because of the 4 persons are left to be examined. This fundamental right of this specific lawsuit this petition.
That you have submitted, I'm addressing that.
That's why I'm saying let them lawsuit come the up-to-date status of this procedure.
Not necessary yet.
Absolutely prejudice to this petition. Because none of the independent witnesses lawsuit implicating this person. Only because of the personal information of the informant that I have mentioned in my petition also.
I'll address that. Your bail application is dismissed. Detailed order will be passed in the chamber.
Yes.
Item 35.
Outline laws.
That's 483 bail regulation, steps taken on 36/2025 to the respondent number 2, my lord.
Notice has not yet been served. Heard Mr. B. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar. It appears from the office note dated 21/7/2025 that the notice issued to respondent number 2 has not yet been served. Stop. Learned additional public prosecutor is requested to inquire about the fate of the notice from the officer in charge of jurisdictional police station and let this court know about it on the next date fixed. When?
Next week in
Monday, Tuesday.
On 2/8/2025.
No, only notice.
Yes, my lord. Otherwise.
Let this case be listed on Tuesday. Tuesday is 29.
Yes, my lord.
Item 46. May I please, Your Lordship? My lord, 60 days offense, 59 days. Today is the 59 days, my lord.
Sorry, my lord, CD not received, my lord.
60 days offense.
My lord. Today is the 59 days, my lord. I have been arrested from 25/5/2024.
What is the punishment?
My lord, 3 years, up to 3 years.
Under section
Under section 75 on sexual harassment, my lord. 75 on reduce section 12 of POCSO.
What is the punishment in 12?
3 years, my lord.
75 1.
2 and 3.
Case diary is there?
No.
CD not received, my lord.
You find out whether charge sheet has been laid.
I'll take a telephonic call, my lord. Otherwise. It is. Well, after some time, my lord, I'll take.
Let him take fine.
Hello. Item 47.
May I please, Your
7, my lord, CD not received.
Lordship, CD not received.
Heard, Mr. What is your name?
I Islam, Lordship.
I Islam, learned counsel for the petitioner. Also heard.
Lordship, the matter fixed on 29 July, Lordship. The same matter fixed on 29 July.
Heard.
Am I right?
Also heard Mr. K. Parashar, who prays for some more time for producing the case diary. When?
This for
29, is it fixed?
Another BA, Lordship. Those are
BA or
BA.
What is the number?
2265, Lordship. 25.
then, my lord.
Let this case be listed again on 25th of July.
Item 38.
38 also, my lord, CD not received.
306, it's under 306. Correct, man. 46 days, today is 46 days. From Nalbari, CD will come from Nalbari.
So next week, my lord.
Heard Mr.
This is Bora.
S.S. Bora, H.S. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case, who prays for some more time for producing the case diary. Prayer is allowed.
31st, my lord.
Let this case be listed on 31st of
1st of August.
1st of August.
Item 49.
Please, Your Lordship.
39 also, my lord, CD not
Lordship, only 39 grams suspected heroin with plastic container, Your Lordship. Total com, Your Lordship.
Case diary?
Is there not received, my lord?
Heard Mr. A.R. Karim, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, who prays for producing the case diary. Some more time for producing the case diary.
Prayer is allowed. Let this case be listed on 4th, 5th of August.
Landing item item 22.
Here in this case, I am on ground of arrest, my lord, notice under section 50 and 58. Ground of arrest.
Same ground also, I will make my submission also on the written submissions. Same also.
Heard Mr. What is the name?
SM Mullah, my lord.
SM Mullah, learned counsel for the petitioner, who submits that the petitioner is seeking bail in this case, mainly on the question of non-furnishing of grounds of arrest at the time of his arrest. Stop. Also, Mr. P.S. Locker, learned additional public prosecutor, who prays for some more time, who prays for allowing him to file a written argument in this case, opposing the grant of bail to the petitioner. The prayer is allowed. When? Same date, 25th.
In the meantime, my lord, registry may take my additional affidavit, my lord, that I have filed long back, my lord, 22/5/2025. Annexing the.
Learned counsel for the petitioner also submits that the petitioner has filed an additional affidavit in this case on 22/5/2025. However, same is not available in his record. The registry is directed to tag the additional affidavit filed by the petitioner with the records on the next date fix. List this matter on 25th of this July.
Landing item 32.
Also, can it be on 29 also?
25th, you are already preparing one. Your submission will remain same. Change the name of petitioner only.
Please, Your Lordship.
Yes.
It's a regular bill application, my lord. I am in custody for 258 days, my lord. Now, there are 7 witnesses, cited witnesses in the charge sheet, my lord. Out of them, my lord, 4 have been examined, including the victim, her father, her mother, and 1 independent witness. 3 witnesses are left, my lord, the IO, the MO, and 1 independent witness. So out of 7, my lord, 4 have been examined. The case has been, charge has been framed under section 74, 75 subsection 2 of the BNS, and section 6 of the POCSO. Otherwise, I don't want to go into the merit of the case, but these sections are inherently incompatible, my lord. The 74 and 75, dealing with outraging the modesty and sexual harassment, are compatible with section 10. And in fact, what the victim has also deposed, my lord, the victim has deposed that the petitioner had touched the private part. So this is in keeping with section 10 of the POCSO Act. So prima facie, my lord, section 10 of the POCSO Act is retracted against the petitioner. And as far as the parents are concerned, because one of our contentions in
Under what provision case has been registered?
Charges have been framed, my lord, under section 74. That is, my lord, outraging the modesty. Earlier, my lord, corresponding provision would be 354. Second section is 75 subsection 2. There is sexual harassment, my lord, corresponding to 354A. And section 6 of the POCSO Act.
Section 6 is
aggravated penetrative sexual assault.
Penetrative.
So these are not compatible, my lord. And from whatever I've seen, my lord, because the victim's evidence has been recorded, the victim has 62.
Yes.
Wait, please, ma'am. The anticipatory bail application, ma'am. My lord would kindly have the Ejahar at page 21.
Anticipatory bail.
Yes.
Charge sheet has been laid.
And my lord, in the charge sheet, my lord, his name is specifically, my lord, mentioned.
Why are you apprehending arrest?
My lord, may I kindly demonstrate the
No.
My lord, trial has started, my lord. 2 dates have passed by.
You have.
We want to appear, my lord. Some protection is given. For
No, you have received summons.
Summons we have not received.
Then.
My lord, may I kindly just explain the matter in a gist, my lord?
2 minutes.
Yes, my lord. My lord would kindly have the Ejahar at 21, my lord.
No, assuming that you are named in the charge sheet.
Yes, charge sheet is there, but my lord, in the Ejahar, my lord, only one of the accused name is there. The other accused person, his name is.
No, we are not going into merit now. In anticipatory bail, we are concerned what caused your apprehension. As charge sheet has been laid, you will receive summons.
My lord, my house has been searched, my lord. It is there in the charge sheet also, page, my lord.
But that phase is over now.
My lord, they are doing it this year also. Right from last year, the case FIR is.
After filing of charge sheet.
Yes, my lord, they have done. My lord, it is a page, my lord. House search, my lord.
In connection with this case,
Yes, yes, my lord.
whether further investigation is going on.
My lord, 25-1.
Mr. Sharma.
Yes, my lord. 25-1-25, the last search was done, my lord, at my house, my lord.
When the charge sheet has been laid.
29. Charge sheet filed on, my lord, 28-1-25. My lord, 3 days prior to filing of charge sheet also. Just 3 days prior.
So that phase is over. Now the question is, charge sheet has been filed.
Yes.
You will receive summons from the court.
Summons we have not received, but my lord, in the charge sheet, my lord, this is regarding, my lord, wildlife protection, my lord. 2 tasks, my lord, elephant tasks are in question, my lord, and 1 motorcycle. These are allegations of poaching.
No, but you have to satisfy the trial court. Why have you rushed to this court?
My lord, because.
Why anticipation?
Lord, because the honorable session judge should have tried the case as per the Assam amendment.
Yes.
Yes. But the honorable magistrate court is doing it. First of all, the court is not the competent court, my lord, to grant us bail. If we go there, they cannot do it, my lord. Because prima facie, it's, my lord, if I may take my this honorable court through the provisions, my lord.
Yes, yes.
7, my lord, may kindly have page 54, my lord. I also have the manual, my lord, otherwise. Page 54.
Which court?
My lord, this is the my lord, sessions court is the competent court. Page
Yes,
56.
sessions court is the competent court.
But magistrate court is doing it.
Where is the
My lord, page 56.
which district?
My lord, Dhemaji.
In which court your case is pending
My
now?
lord, my lord, sub-divisional judicial magistrate court, Dhemaji. My lord, page 57, annexure 4. 2 dates have gone by. 3 dates have gone by. In fact, 22/7 also there was 1 date. Annexure 4, 57 and 58.
What is the maximum punishment?
My lord, 7 years. Under section 51, my lord. It is there in the Assam Amendment Act, my lord.
Still the court in which it is pending, it can grant bail. There is no embargo.
Nothing has been found against us, my lord. There was a forensic done. My lord, what they have recovered are 2 elephant tusks and
No,
the
no.
motorcycle.
We are not on that. These submissions you can make before the trial court.
Yes.
What caused you apprehension of getting arrested?
My lord, they are looking for us, my lord. Since last year, we have not been able to come back to our home because, my lord, we are not involved in the incident. My lord, we are
now after filing of the charge sheet, unless the court declares you an absconder, no process would be issued, must have been issued against you, except summons.
They were aggressively searching us, my lord, for no fault of ours, my lord. That is why we are.
When the last search was made?
25/1/25.
After the charge sheet has been laid.
Charge sheet has been filed.
So after laying of the charge sheet, your fear goes.
No, my lord. Fear is still there, my lord. Because it's a non-bailable offense, my lord.
But the court in which the case is pending,
not the competent court.
Who can arrest you without issuing warrant?
My lord, as per these provisions, my lord, these are non-bailable offenses.
But after laying of charge sheet, whether investigating officer still, whether they can arrest you.
After laying of charge.
So charge sheet has been laid. Yes. You appear before the trial court and make prayer before the said court.
Some protection may be given.
No protection. I will only make observation that the competent court is Court of Sessions.
My lord, CD may then be called for one.
No. We will not go into that. Heard Mr. P.R. Sharma. Yes, Mr. Sharma, what is that, sir?
That my lord, comitial part is not happened, my lord, at this stage, my lord.
Only my lord, search sheet is filed before this court, my lord. And my lord, this court will, my lord, commit, my lord, the session tribal, my lord, case. Immediately, my lord, trial will be before the, my lord, honorable session court, my lord.
My lord, and whom to take bail in front of, my lord, because now as the Honorable SDJM is conducting my case, now there will be a confusion, my lord. That is the
Bail
problem.
application may file before this.
My lord,
Before
if I
this
am
court
protected,
also.
my lord, then I may go to the competent court, my lord, in a time-bound manner, and I'll apply for regular bail, my lord. Then can, if it only if it pleases, my lord, that can also be done. Time-bound manner.
Heard Mr. P.R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor.
My lord, special PQ, my lord.
Sorry,
number two.
learned special public prosecutor.
Or respond number 2.
Special public prosecutor. This application under section 482 of BNSS has been BNSS 2023 has been filed by the petitioners, namely Dilip Patir, alias Kete Patir, and Dibesh Pait, who are apprehending their arrest in connection with PRC case number 43/2025, corresponding to Jonai PS case number 39/2024 under section 120B/353/353 of the Indian Penal Code. And say, what is the punishment under 353?
My lord, maximum 5 years, my lord.
And section 51
51, my lord, 7 years.
of the Wildlife within bracket Protection Act 1972. Stop. Learned. Where is the FIR?
FIR is a page, my lord, it starts from 14 and relevant is 15, 16, my lord.
The gist of accusation in this case is that
Ajahar is 21, my lord.
that on 10/4/2024, one Saroj Dole had lodged an FIR, inter alia, lodged an FIR before the officer in charge of Jonai police station, inter alia, alleging that on receipt of information through credible sources that some miscreants are involved in wildlife poaching, and would be dealing with ivory tusk and are carrying ivory tusk. Stop. A such team was constituted and and the suspected poachers are ambushed. Stop. The poachers escaped, taking the advantage of large bamboo grooves. However, from where ivory tusks were, however, two tusks were found two ivory tucks were left behind by the miscreants while escaping. Stop. Learned counsel for the petitioner has submitted that the petitioners, two petitioners are there. The petitioners are not involved in the offense alleged in this case. However, they were being searched. No, however, the police were searching for them after lodging of the FIR. He also submits that police even visited the residence of the petitioner whose residence?
On various dates, my
The
lord.
petitioners on various dates.
I'll just.
However, stop. Learned counsel for the petitioner submits that in the meanwhile, charge sheet has been laid against both the petitioner before the court of learned SDJM M. Jonai, and he is apprehending SDJM as Jonai. Stop. Learned counsel for the petitioner submits that though the petitioner has not received any summons from the court, however, he is apprehending that if he appears before the said court of learned SDJM as M. Jonai, he would be remanded to custody as the offense under which offense for which charge sheet has been laid is triable by a special court, that is the court of learned Sessions Judge Themaji. Stop. On the other hand, learned Special Public Prosecutor has submitted that in this case, charge sheet has already been laid and the petitioners have not yet received any summons from the court of learned SDJM M. Jonai. The said court, he also submits that though the offense under Section 51 of the Wildlife Protection Act 1972 is triable by the special court, that is court of Sessions Judge, however, presently the case is pending before the committal court and it would certainly commit the case to the competent special court. Stop. In Forest Act cases, charge sheet has to be directly filed before the
Really, my lord, it is a previous case. My lord, that section, my lord, that wildlife section, my lord, that comes, my lord. Actually, it is investigated by Jonai police.
Stop. He submits that there is no apprehension of getting arrested, apprehension of the petitioners getting arrested as on date. Stop. I have considered the submissions made by learned counsel for both the sides. The competent court to try the offense under Section 51 of the Wildlife Protection Act 1972 is the Court of Sessions. However, as the maximum punishment which can be imposed under the penal provisions in which the charge sheet has been laid is only 7 years, even the Court of Learned SDM Jonai is well within its powers to consider and grant bail if it finds it fit to do so. And stop. Moreover, as charge sheet has been laid, the said court would certainly issue summons to the petitioner before taking any coercive measures. Hence, this court is of considered opinion that at this stage, there is no apprehension of the petitioners getting arrested in connection with PRC case number 4325. Stop. Accordingly, this anticipatory bail application is disposed of with an observation that even that the petitioners may appear before the court from which they receive summons and may pray for regular bail before such court if so advised.
My lord, kindly, my lord, page 55, my lord, the Assam amendment, my lord, kindly see, my lord, that section 2B, my lord.
Years.
My
lord, for the words 3 years,
Yeah,
7
it is
years,
substitute.
in section 51 of the Wildlife Protection Act, as per my humble understanding, in section 51 of the Wildlife Protection Act, the Central Act, it's laid down 3 years. So 3 years will be 7 years, my lord.
Then 7 years, then, and my lord, that B, and then my lord, that letter number 2. That may be, my lord.
No, still, even if it is 10 years, still SDGM can grant. It would not make any difference. You appear before the trial.
Item 63. I'm deeply obliged, my lord.
Dispose of, my lord.
Disposed of.
Deeply obliged, my lord.
Item?
May please lordship, the charge case lordship, petitioner is behind the bar 437 days lordship.
Lordship, in this case, lordship, you could not go through the
437, how? 1 year and?
No, 1 year is not completed lordship.
437 and 1 year has not.
237.
237.
237 lordship.
And what is the contraband? It is NDPS Act or POCSO.
POCSO, side merit lordship.
Who is for the?
Lordship, the total witness is 15 lordship. The examination
D.K. Bhattacharya.
out of 6 witnesses was examined lordship. Only the 5 witnesses have no materials against the hanging lordship, the postmortem.
You need some time to go through. And today the amicus is also not present.
Friday.
Tuesday. 1st August. Heard Mr. N. Ahmed, learned counsel for the petitioner. Also heard Mr. P.S. Lokal, learned additional public prosecutor. Though name of Mr. D.K. Bhattacharya has been shown as amicus curiae appointed to defend the cause of the respondent number 2, however, he was not found on call. Stop. Learned additional public prosecutor has sought some time to go through the records before he makes submission, as he could not prepare this case. Stop. The prayer is allowed. Let this case be listed on 1st of August.
31st lordship.
Why
The
31st?
lordship, the 1st August, lordship, I'm the out of station.
You are out of station.
31st.
Okay, 31st.
Item 64.
This case, we have not received the FSL report also.
Please question.
And on last occasion, my lord, they appointed our submission, my lord, and today for perusal of case diary.
Mr. K.K. Das was there. Whether apart from statement of the case diary is there? No, their plea is that apart from statement of the co-accused, there is nothing in the case diary. That is your plea. Or what is your submission?
Yes, Lordship.
That you
After a few minutes, Lordship.
let him go through.
Hearing items 40 and 41.
May I please, your lordship? Anticipatory bail application, my lord. FIR is on page 10, my lord. Particular portion is page 12, my lord.
Well, Lordship, updated case was called for, but we have received the CD, but it is not updated. It was last date of entry, His Lordship, 15/11/2024. Last date of entry of the CD.
Whether victim's statement is there.
Victim statement is not there, Lordship.
Matter is pending, my lord, since 9/1/2025, my lord.
What is there in the petition, Lordship?
Why it is not updated? It is updated till when?
Lordship, last date of the entry of the CD is 15/11/2024.
May I submit, my lord, on 17/6/2025, my lord, up-to-date CD was called for, my lord. Till, my lord, up-to-date CD is not reviewed. Matter is pending, my lord, since 9/1/2025, my lord. Bail matter, anticipatory bail.
What is the offense?
Offense, my lord, under section, my lord, 143, my lord, kidnapping, and 3(5) common intention, my lord. Victim girl has already been recovered. California's instruction was there, my lord, on which basis, my lord, interim protection was given to the present petitioner, my lord.
You are on interim.
Interim, my lord.
Then let them bring the updated case diary. We will extend the interim.
Item 41 is also same FIR, my lord.
Heard Mr. S.A.B. Kabir, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that though the case diary is available, it is updated only till 15/11/2024, and the statement of victim girl is not there in the case diary, and therefore he submits to call for therefore he prays for some more time to produce an updated case diary. The prayer is allowed. When?
12/8.
Let the 12/8. 20 August. Let this case be listed on 20 August. The interim order shall continue till next date. Next item, 41, same order, same council.
Item 42.
Deeply obliged.
Please, your lordship.
Yes.
Actually, it's a charge-sheeted anticipated bail, lordship. In connection with special POCSO case number 6/2025 arising out of Selafta police station case number.
In POCSO matter, why anticipated bail after charge sheet?
After charge sheet, lordship. After, no, sir.
You are named in the charge sheet.
Charge sheet and also in the FIR, lordship.
You have received summons.
No, lordship, but NBW was issued in the very first date, lordship.
Okay.
LCR is there, lordship. Black mark in the LCR also. LCR, this LCR, sorry, LCR. And there are 3 accused. 2 of 3 accused already been enlisted on bail, lordship. I'm only the.
You are shown as an absconder in the charge sheet.
Yes, sir.
No, you appear before the trial court. Trial court will decide.
Some protection may be given, lordship, because if I am taken into custody, so all the 2 accused are on is out. So, lordship. So every possibility is there, long detention. Some protection may be given. I'll face the trial, lordship. All along,
When is the next date fixed?
12 August, lordship.
12th August.
Yes,
Very honorable Mr. S. Das, he was basically
Yes.
performance matter. The appears that a warrant of arrest is pending. If your lordship is inclined to keep that at abeyance and let him appear.
but whether under, while taking up bail application under 482, that can be done.
My understanding of 482 is that not 482 is inherent to this code, it can always.
Not 482, 528.
528 can
So even if there is no application, that power is there. Okay. Heard, Mr. What is your name?
Yes, Hussain.
S. Hussain, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This also heard Mr. S. Nawaz appearing for Mr. S. Das, learned amicus curiae for the respondent number 2. This application under section 482 of BNSS has been filed by the petitioner, namely Nathuram Rajbangshi, alias Sri Nathu Rajbangshi, who is apprehending his arrest in connection with special POCSO case number 6/2025 arising out of Silapathar PS case number 182/2024 under section 61 within bracket 1, 65 within bracket 1, 75 within bracket 2 of BNS, read with section 12/6 of the POCSO Act 2012. Learned counsel for the petitioner has submitted that in the aforesaid case, charge sheet has been laid against 3 accused persons, including the present petitioner. Stop. It is submitted by learned counsel for the petitioner that the petitioner has been shown as an absconder in the charge sheet, and by order dated 15/2/2025, learned special judge Dhemaji had issued non-bailable warrant of arrest against the petitioner at the first instance itself at the time of taking cognizance of stop. Learned counsel for the petitioner has submitted that the petitioner is apprehending his arrest as the offense involved is under POCSO Act and a non-bailable warrant of arrest is pending against him. On the other hand, learned additional public prosecutor has submitted that the court of Special Judge Themaji is competent enough. He is having power to consider bail application for the offences under which charge sheet has been laid, and therefore there is no legal embargo on granting bail by the said court, and therefore the apprehension by the petitioner of getting arrested does not have any basis. He further submits that regarding the fact that the petitioner is also aggrieved by the issuance of non-bailable warrant as on the first instance itself, he ought to have approached this court by filing a application under section 528 of BNSS. Stop. Learned amicus curiae, Mr. S. Nawaz has submitted that
since the Court of Learned Special Judge is competent to consider the application for bail and to grant it if it fits it, if it deems fit to do so, the petitioner may be directed to appear before the trial court on the next date fixed in the aforesaid case, and to facilitate his appearance, the inherent powers of this court under section 528 may be exercised. Stop. I have considered the submissions made by learned counsel for both sides. It appears that the trial court, that is the Court of Learned Session Judge Dhemaji, was not right in issuing the non-bailable warrant of arrest on the first date itself after receipt of the charge sheet in the above mentioned case. Stop. It is no res integra. It is no longer res integra that even if an accused has been shown as an absconder in the charge sheet, the trial court has to, at the first instance, issue summons to such an accused, which has not been done in the instant case. Stop. This court is also of considered opinion that the Court of Special Judge Dhemaji is competent enough to consider and grant bail to the petitioner if it finds fit to do so. Hence, the petitioner is directed to appear before the Court of Learned Special Judge Dhemaji on the next date fixed, that is on 12th August 2025. Stop. To facilitate the appearance of the petitioner before the said court, this court, in exercise of its inherent powers under section 528 of BNSA, directs that the non-bailable warrant of arrest issued against the petitioner by the trial court shall be kept in abeyance and shall not be executed till the next date, that is till the next date fixed by the trial court, that is 12th August 2025. This bail application, anticipatory bail application, is accordingly disposed of.
Some protection may be given.
Protection I have given whatever I can give.
Okay. Then 43.
Yes.
May I please, Your Lord? Well, it is a 482 application, man. And my lord, I have been served with the notice 67 of the NDPS Act to appear because, and my lord, latest receipt I have been asked again on 29th of July, since the letter, man. 29th of July, and they have to ask me some question. So, because since the case is non-bailable one, that's why I am before your lordship for protection. I am ready to appear, man. I am having a shop of electronic goods at Karimganj. And so I hope some co-accused from whom their contraventions have been recovered might have implicated me. That's why, my lord, my learned friend has submitted an objection. And I prayed before your lordship to peruse the CD whether there is any material except the allegations of the co-accused.
Yes.
Updated case diary, that is structural and line of three judgment, one by Dishonorable Court, two by Lords. Paragraph 6 and 7 of
You have to overcome embargo of 37, even in the anticipatory bail. Suppose there are some material against you. Oh, okay.
Yes,
Show me the materials.
even if there is a case, protection, Lordship will give me for 10 days, 15 days protection.
No, that protection cannot be granted unless you jump 37 embargo. You have to cross that embargo. If there are reasonable grounds in the case diary to believe that you are involved, then
Reject it, definitely.
yes, show me what is there. What is there? What is the case? How much?
7 kg, 7.473 kgs of methamphetamine tablets.
Okay. Where is the complaint?
Doctor, the investigation is going on now. Because
On what basis the investigation? Some initial complaint is there.
yes, Lordship is there. So they have not annexed. It is available in the case diary also. Lordship, page 9 of the bail application. Panchnama is there.
Page 9.
Page 9 of the bail application.
Yes, what is this? Caesar.
On 12/3/2025 at about 10:30 hours, I, Prem Inspector of Narcotic Control Bureau, General Unit Guwahati, and information from Sri Kaushik Sarkar, Inspector NCB, that on 13/3/2025 at about 1:20 AM, one person, namely L. Locosanso, will carry 7 to 8 kgs of methamphetamine tablet in vehicle from More, Manipur, and supposed to be delivered the said consignment at Assam to someone. A photo of the suspected persons so is annexed herewith and is prohibited. On 12/3/2025, the above information was typed by me in NCB number 1 and the office of the NCB Guwahati. And on the same day at about 10:30 hours, the NCB number 1 was put up by me before KB Ravinchan Gaunte, Superintendent of NCB Guwahati, Journal Unit, on the basis of NCB 1 on dated 12/3/2025, KB Ravinchan Gaunte, Superintendent of NCB, issued an office order number so and so, in which the team was constituted and I, Prem Narayan Jha, Inspector, was authorized to search and seizure. In persons of stated so and so, I, along with NCB Guwahati team, Inspector so and so, so and so, so and so, at about 12 hours, reached near Lalipur Police PP under PS Dholai, Kachar, Assam. On 13/3/2025, at about 12 hours, the team of the NCB Guwahati approached the Inspector Lalipur Police Station under PS number so and so. Thereafter, after obtaining police assistance, the NCB team arranged 2 local independent witnesses, namely so and so, so and so, to whom shared the information which had with the NCB team, and also requested them to witness during the search and seizure procedure. Then Lordship, on the same day, Lordship, the containment was seized. Thereafter, an investigation, Lordship, the involvement of the petitioner was found. Then Lordship, notice under section 67 was issued.
Where is the involvement?
Lordship, it is available in the case that we have flag mark the necessary point. Lordship, thereafter, notice under section 67 was issued to him. Lordship, in our objection in paragraph 6, page 27.
Yes.
Lordship, involvement is narrated in paragraph 2 and 3 of my objection, page 26.
Yes.
That accused so-and-so in his voluntary statement given in section 67 had revealed that the methamphetamine tablet seized in the instant case was supplied to persons, namely Daniel Mete, so-and-so Manipur, and receiver of the said contraband was Iqbal Bahar, the present petitioner. Then paragraph 7, that during the investigation, CF and CDR of mobile numbers of accused and suspected persons have been obtained from telecom service providers. From analysis of CDR mobile of Iqbal Bahar, alias Iqbal, it has been found that Iqbal Bahar was continue in touch with the accused. Then Lordship, paragraph 5, the 2 times 67 notice have been issued to Iqbal Bahar to appear before IO NCB. He did not appear before IO, and the advocate of the petitioner submitted a letter each time regarding his health issue. Then Lordship, paragraph 6. It is respectfully submitted the petitioner Iqbal Bahar has deliberately avoided cooperation with the investigation by not appearing before the investigating officer, despite being issued multiple notice under section 67C of NDPS Act. The first notice dated 9/4/2025 required the petitioner to appear before IO on 23/4/25. However, 22/4/25, the petitioner was submitted. Some petition was submitted by the advocate on behalf of him for seeking adjournment on medical ground, stating that the petitioner was suffering from various serious health issue and prevented him from traveling. Notably, no supporting medical documents were attached at that time. Thereafter, a second notice under section 67C was issued on 1/5/25, urging the petitioner to appear before the IO on 25/25. Once again on 2/25/2025, his advocate submitted another petition seeking adjournment on similar medical ground. This time, the petition was accompanied by a prescription dated 19/5/25, 1 day prior to scheduled appearance date, issued by Dr. Amines Das. Advised bed rest for 7 days. It is further brought to the kind notice of this honorable court. The petitioner filed an anticipatory bail application before the Honorable Guwahati High Court on 3/5/25. The accompanying affidavit was signed by the petitioner in Guwahati as evident from the close link, and I signed so that this clearly indicates that the petitioner traveled from Karimganj to Guwahati during the same period in which he claimed to be medically unfit to travel to NCB office. It is relevant to note that the petitioner has already traveled from Karimganj to Guwahati to sign the affidavit in support of his anticipatory bail petition. This directly contradicts the claim that he was physically incapable of appearing before the IO. These repeated instances of avoiding investigation and proving inconsistent or questionable medical justification point to clear pattern of willful non-cooperation with investigation. Lordship, with regard to information gathered by the IO from other accused, Lordship, this has been dealt by the Honorable Supreme Court in case of Samarth Kumar, Lordship, paragraph 6 and 7, Lordship.
In which case?
Is Samarth Kumar, State of Haryana. The second reverse page, Lordship, I have marked the paragraph 6 and 7.
What is that? Yes, please read. In cases of this nature, the respondent may be able to receive.
Okay, paragraph 8. Paragraph 8. In case of this nature, the respondent may be able to take advantage of the decision in Tufan Singh versus State of Tamil Nadu, perhaps at the time of arguing the regular bail application or at the time of final hearing after conclusion of the trial. The next paragraph. To grant anticipatory bail in case of this nature is not really warranted. Therefore, we are of the view that the High Court fell into error in granting anticipatory bail to the respondent.
No, what happened in that case?
So, in this case, the Honorable Punjab and Haryana Court granted anticipatory bail to the accused person on the ground that he was made accused on the basis of statement of other persons. That has been clarified in paragraph 8 also.
Lordship, another judgment, another order of the Honorable Supreme Court. Lordship, in the case of Anarul SK versus State of West Bengal. It was given on 19/9/2024. Lordship, paragraph 4. In this case also, the Honorable Calcutta High Court granted bail to the accused. Paragraph 4. The grant of anticipatory bail in case involving narcotic and subject substance is a very serious issue. We therefore direct the state to consider as to whether it proposed to file an application for the cancellation of bail granted to the court of this question.
Okay, that is a different.
And Lordship, our High Court also, that judgment is on last occasion I placed before your Lordship. In my learned friend appeared for the petitioner, but in this case also anticipated bail was rejected, sir.
But in many cases, coordinated bench has granted bail.
Yes, what is your response to the judgment cited by the NCB Council of Samarth Kumar?
No, I have nothing to say. Because in my case, bail was rejected. It is Ajay Kumar Tiwari. Bail was granted first day. Next day evening, I was called again that in view of Supreme Court guideline, I cannot grant you bail. That is given. Why I have to admit it. This is a fact. But question is that the NCB has got enough power. If I am involved, they can arrest me. They can arrest SC Vishwas. No question of 67 is requirement. Why they are doing this game of sending letter under 67? We have to question you.
No, they may not arrest you also. If
Yes.
they find some.
Yes, that's why I am afraid because they may arrest me. That's why I want some protection.
That protection, this case is saying.
Give me for 7 days protection, my lord, I will appear. Thereafter, I will again come. In
Such-
between, protection may be given. Thereafter, your lordship may cancelling. It's a curtailment of the liberty of the individuals, my lord. We are saying many things about Constitution, 21, 22. But in every step, government of India and government agencies are curtailing the liberty of the citizens. And your lordship knows the view of the Apex Court regarding other agencies' action.
No, unless you show a counter to Samarth Kumar.
No, that is the Supreme Court has rejected, discarded. That is true.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. S.C. K.L., learned additional public prosecutor.
Standing counsel in
Sorry. Learned standing counsel in CB. This application under section 482 of BNSS has been filed by the petitioner, namely Iqbal Bahar, alias Mamun, who has been apprehending his arrest in connection with NCB case number 3/2025 under section 22C/29 of the NDPS Act 1985. The gist of accusation in this case is that on receipt of an information through reliable sources that one L. Lungkhomang, Lunkhommang, Mate, Mate, would be carrying 7.8 kg of methamphetamine tablets from Manipur, from More in Manipur to Silchar to hand it over to someone. A Naka checking was arranged
at Lailapur police post. Stop. During the Naka checking operation, one Mahindra XUV vehicle number 500 XUV 500 vehicle bearing registration number AS10 BV 4318 was intercepted and 7 point. How much methamphetamine was recovered?
7.4.
7.43 kgs of methamphetamine tablets were recovered therefrom. Stop. Learned counsel for the petitioner has submitted that the petitioner has received a notice under section 67 within bracket C of the NDPS Act 1985 in connection with the aforesaid case. Stop. He submits that learned counsel for the petitioner submits that the petitioner is in no way involved in the offense alleged offense in which no way involved in the case in which the aforesaid contraband was recovered. Who are you? You have a
Electronic businessman, Karimganj.
it is submitted by learned counsel for the petitioner that the petitioner is a businessman dealing with the business of electronics at Karimganj. Stop. He further submits that the petitioner is ready to cooperate in the investigation. However, as non-bailable offense under section 22C/29 of the NDPS Act is involved in the case, he is apprehending that he may be arrested in connection with the case. He also submits that apart from the statement of the co-accused, there might not be anything on record and against the present petitioner, and in view you are relying on some judgment, Tufan Singh.
Tufan Singh is always there. This is
And
my only protection, only co-accused.
and he submits that in view of the ruling of the apex court in the case of Tufan Singh versus State of Tamil Nadu, citation de dena, Tamil Nadu, the statement of co-accused may not be regarded as an incriminating evidence against the present petitioner, in the aforesaid case. On the other hand, learned Standing Counsel NCB has vehemently opposed the grant of anticipatory bail or any interim protection to the petitioner at this stage, as he has at this stage. Stop. He submits that prior to the issuance of notice dated 8/7/2025 under section 67 of the NDPS Act to the present petitioner, notices under the aforesaid provision were issued to him on two prior occasions, and on both the occasions the petitioner has defaulted in appearing before the investigating agency. Learned counsel, Standing Counsel for NCB also submits that the co-accused who was arrested along with the contraband has, in his voluntary statement recorded under section 67 of the NDPS Act, has implicated the present petitioner, and there are materials in the case diary to indicate that the present petitioner was the intended recipient of the contraband which has been seized in this case. He submits that even for grant of anticipatory bail, the petitioner has to overcome the embargo of section 37 of the NDPS Act. He further submits that at the stage of investigation, the when an application under anticipatory bail has been filed in a case involving commercial quantity of NDPS Act, the observation of the apex court in the case of Tufan Singh versus State of Tamil Nadu, within bracket Supra, would not come into aid of the petitioner. To support his submission, in support of his submission, Learned Standing Council NCB has cited a ruling of the apex court in the case of State of Haryana versus Samarth Kumar, reported in 2022, 0 Supreme, within bracket SC 1562, wherein it has been observed by the apex court as follows. Quote para 5 and quote para 8 and 9 from the aforesaid judgment. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of NCB case number. NCB case or crime number? NCB crime number 3/2025. It appears on perusal of the case diary that at this stage, the statement of the co-accused recorded under section 67 of the NDPS Act implicates the present petitioner of being the intended recipient of the contraband which was recovered in this case. Stop. The apex court in the case of State of Haryana versus Samarth Kumar has observed that in cases of such nature, the respondent may be able to take advantage of the decision of Tufan Singh versus State of Tamil Nadu only at the time of arguing for regular bail application or at the time of hearing after conclusion of trial. However, it has observed that grant of temporary bail is not warranted in such cases. Stop. In view of the observation of the apex court, this court, in view of the observation made by the apex court in the aforesaid case, the prayer for anticipatory bail of the petitioner is rejected at this stage. Send back the case. Samarth Kumar Yatase. Item number? 36.
36.
POCSO.
My lord.
Appear before the trial court. Heard Mr. A. Parmanik, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid, bearing charge sheet number
141/2025, dated 15/7/24.
In view of the fact that charge sheet has been laid in this case, this bail application is disposed of with an observation that the petitioner may approach before the trial court and may file a regular bail application before the said court, if so advised.
Item 64.
Yes. Yes.
Lordship, I have seen Lordship. It is true that the other co-accused has named him Lordship. The person whose possession this tablet has been found, he has also named. Moreover, his statement is also there. The present petitioner Lordship. He also admitted that Lordship. He used to sell these things and he used to purchase from the Sober Ali, the person from whom the possession this tablet has been found. Moreover, Lordship, in the statement of one witness, it is stated as statement of witness, he has stated the name of this person and other person name also.
What?
Occasion Nisha Jukta tablet for Uporio and Manu for that অবৈধ ভাবে বিক্রি কৰিছিল বুলি জানিব পাৰো।
What was seized in this case?
Tablets, Lordship, Simplex. Moreover, FSL is also not received, Lordship. It is 180 days, but it is 90 only, Lordship. Investigation is going on. And I also wanted to state here, Lordship, with humbly submit that, Lordship, the Tufan Singh is applicable in the case of trial, Lordship. It is during-
Just now I have read. It is applicable in case of regular bail also.
Okay, Lordship. The thing is that only.
Apart from co-accused, nothing is there.
No, Lordship. One witness statement is also there.
That is a general statement, not in respect of the seized contraband.
Lordship.
Heard Mr. H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely, what is your name?
Shohidul Islam.
Shohidul Islam, who has been detained behind the bars since 24/4/2025, within bracket for last how many days?
93 days.
93 days in connection with Tamulpur PS case number 108/2025 under section 22C of the NDPS Act 1985. The gist of accusation in this case. Any co-accused has been released? No.
No instruction.
The gist of accusation in this case is that, where is the FIR?
Number 12, my lord.
That on 21/4/2025, one Mohendra Soikia had lodged an FIR before the officer in charge of Tamulpur police station, inter alia, alleging that and information was received through reliable sources that some individuals would be carrying psychotropic tablets somewhere near Suleiman Basti, Stop. On receipt of the said information, a search team was constituted and a Naka checking was organized near Suleiman Basti, and one suspected person who identified himself as Sabor Ali was apprehended. During search of this said person, 1935 grams of Sampax plus capsules suspected to contain tramadol was recovered from his possession. Stop. Learned counsel for the petitioner has submitted that the petitioner is innocent and in no way involved in the offence alleged in the FIR. He further submits that the petitioner has been implicated only in the above case only on the basis of statement of the co-accused Sabor Ali. Apart from the statement of co-accused, there is nothing in the case diary which implicates the petitioner. Learned counsel for the petitioner has submitted that in view of the observations of the apex court, in the case of which case you are relying?
200.
What is the citation?
Was reflected from the last paper number. I'll give my letter. I'll give.
I'll defer this case. If you are not ready with citation on which you are relying,
That copy was given on the next.
you don't know the citation.
2022.
You give the citation, otherwise, because that is your main basis on which you are before this court. Learned counsel for the petitioner has relied on the submission on these rulings of the apex court in the case of Tufan Singh versus State of Tamil Nadu reported in. You give the citation. Stop. On the other hand, learned additional public prosecutor Mr. K.K. Das has produced the case diary of Amulpur PS case number 108/2025 and has submitted that there are incriminating materials in the case diary against the petitioner. He, however, submits that at this stage, apart from the statement of the co-accused, other materials against the petitioner are yet to be collected.
One line also, official also not.
He also submits that the forensic laboratory report is also not received in this case. I have considered the submissions made by learned counsel for both the sides and have gone through the case diary of Tamulpur PS case number 108/2025. So upon perusal of the case diary, it appears that the petitioner has been implicated in this case on the basis of the statement of the co-accused persons. And apart from said statement, at this stage, there is nothing in the case diary which implicates him in the offence alleged in the FIR. Stop. The observation of the apex court in the case of Tufan Singh versus State of Tamil Nadu. You have to be ready with the citation, not only citation, but also judgment, main judgment on which you're relying.
Petition number 2021 4HCC.
Okay,
Phase one.
where is the judgment?
It was reflected in another order, my lord.
You are going to war without your arms and ammunition. Just out of the Calica. So saying dot. The how much contraband was the you are
1935.
Baki chamber में देंगे 50,000 with one surety of like amount, subject to the satisfaction of learned special judge Baksa with certain conditions. The other matters
Interim order, my lord, that may be extended.
interim, wherever there is interim, it will continue.
In item number 42, 44 to 47, I have appeared for informant. Earlier occasion, my lord, CD was there, but today CD is not available. So,
It will be leftover. It will be shown as leftover.
my lord, by the time CD may be called for, they are CD I said, today.
Produce the case diary on the next day.
Not received. But
They will produce the case diary on the next day. No orders.
Interim is there.
Wherever there is interim will continue.
My